back. I hate when I'm fucking muted, dude. That fucking sucks ass. God damn. Okay, at least I realized this time, because sometimes I won't even fucking realize for like a full fucking 5-10 minutes, and it's just like, damn, that sucks. Okay, anyway, fucking, first of all, today, we're gonna be starting with the fucking, big tech trial discussion here. Well, not starting with, it's the whole live stream, but we'll be starting with, we had initially went over the initial complaint, and then there was an amended complaint that I found, that I noticed after. And so today we're just going to be going over the differences that I highlighted. It's literally just like one thing, basically. Well, it's actually a couple of things technically, but yeah, we'll go. It's not much, but we'll get there. And we're gonna go over that, and then we're gonna fucking continue our coverage. Also, looking at the monopolization of search and advertising in regards to Google. And we'll look at the draft for, well, it's not a draft, it's what was filed. We will look at what was filed for the motion of the plaintiffs' appellees to dismiss the appeal. And we're also going to look at some past sanctions that I noticed that Google may have. I believe Google was sanctioned, and whatever the proper words are for that fucking shit. And then fucking, we'll also be looking at why, which is, we'll look at what it shows us in the discovery regarding attorney-client privilege, and we'll talk about that too, as it relates to the other coverage we've done. Um, and then we're also gonna, if like I have time, I think I can in this live stream, I might also then get through some of the news coverage, basically like the rest of the news coverage if I can, perhaps, that I had previously prepped on this material that I didn't get through. So yeah, so previously we went over our pre-trial submissions, we've gone over trial materials plus the initial complaint, and now we're going to continue exploring our discovery and case management documents, with our available appellate brief. And then next up, we're going to go into trial exhibits. So the trial exhibits I think are really important because I think that's the most information we're going to get potentially about the inner workings of Google. And I think it's not only important for every human being because of the way they control our access to finding out information and things like that, but also particularly with people who are in business and people who do marketing. For us, it's going to be the most understanding we get on how we are able to do our fucking jobs. You know what I'm saying? Because for me, it's like no matter what it happens with this law case or legal case, whatever words, I don't know, fucking every change that happens with algorithms and marketing and the website, it's all based on the history of what happened before it, and it's just continuous building, building, building. So the more we understand about all of this, the more we can understand about where we're going in the future and how what we've been doing, um, processing what we've been doing, basically. I don't know if I'm making sense. Yeah. Okay, so today we're going to be basically going through all of that. I'm going to roll my fucking intro. I feel like I'm a bit of a mess, but whatever. Um, so, yeah, I want to roll my fucking intro, and then let's do this bit. Hi, my name is Alexis, also known as Lexi or Deaf Child. I was born deaf, hard of hearing. I began doing business as Deaf Child 2013, marketing 2011, sales 2009. I've earned 50 plus certifications in marketing and sales. My Bachelor of Science from Loyola University, New Orleans, with a music industry studies major and a business administration minor. Deafness runs in my family genetically. Speech is not fully accessible to me. Anyway, I'm here to bitch about whatever the fuck is on my mind. So here we go. Visit my site at noladeafchild.com. Okay, so sometimes, whenever I click on the links available from the initial documentation that is linked on justice.gov or whatever from the U.S. Plaintiff States, like if I click on these links and then I copy the URLs and I put them like into my YouTube descriptions, or if I send them to someone in email or something, when I go click the link again, it'll give me this fucking server error like thing. But then like if sometimes, but then like if I click it direct, let's see if it does it here. Oh no, now it wants to work. Okay, whatever, I feel gaslit. Fucking like sometimes I swear to God though, if I click this fucking shit, it'll give me this like server error like message thing shit I can't even fucking properly articulate. And I will have to go fucking like back, but then if I go back to the Department of Justice website and I go click it from here, it'll work somehow. I don't know. Am I making sense? Let's see if it works now. Oh, it's still working. Okay, I felt gaslit. This is just like, so one time I had like I replaced the fucking light bulb, like, and I kept replacing the light bulb, but fucking this one light in my house and one of my previous houses that I lived in wouldn't work. It would like always like do this flash thing and not fucking work, right? And so like I literally get the landlord to send some dude to come fix it. And when the dude comes, it decides that day it wants to fucking work. And I'm just like so annoyed because I feel gaslit. But I have video, but I was like, this is just like that though. Anyway, but sometimes if you click that shit, it doesn't work. Come back to this thing, it'll work just fine. Okay, so, the first things that I wanted to check out here is we had previously looked at the initial complaint regarding the discovery and case management documents. And then whenever I was going through the case management documents, I realized there's an amended complaint. And I was like, oh shit. So, I was like, what if there are changes? What if other things happen that I didn't know about? So I went through the entire original initial complaint as well as the entire amended complaint, and I downloaded the amended complaint and I imported it it changed the font when I did, but I imported it into Canva, and then I highlighted the differences between the amended complaint and the initial complaint. So, from what I can find, there's only one big difference that's technically kind of occurring in like two places of the what am I saying, contract of the fucking document. Um, but basically, for the original complaint, they added Wisconsin, and that's literally all we need to know. Is they added Wisconsin to the lawsuit in the amended complaint. That's the biggest, only the fucking difference really between the initial complaint and the amended complaint is Wisconsin is added now. And then in section 15 down here, they also add Wisconsin here. And I literally went through the whole thing, and I couldn't find any other differences. So if there are any other differences, I'm sure they could be there, but I just missed them. But I think that everything is the exact fucking same. So I covered the initial complaint in my previous live stream on all this. I read the entire fucking thing. The only difference between the initial complaint and the amended complaint, add Wisconsin. Don't forget Wisconsin. So yeah, fucking that's all we need to know there. Let's see, I'm gonna go ahead and exit out of all of that. And so next up, I noticed, here, I wanted to go ahead and cover because I'd also like not in my last live stream, but in the one before that, where I initially went through everything and then covered some of the news sources. Fucking, we also, saw one of the people who was speaking in the news reporting. I think that was from like the CBS news thing that I covered on this. But they had discussed, how there was going to be an appeal. And so in the appellate briefs, there's already a motion to dismiss the appeal, or a motion of a plaintiff's appellees to dismiss appeal. So I don't know if this could have been a different appeal in regards to, like, let's see if there's, yeah, so that's it. I don't see in here any documentation of another appeal related to the case. So I'm assuming, but not entirely sure, that this is about appealing possibly a preemptive motion to go ahead and dismiss any appeal they could submit or something. I don't know. But also, the appeals that they submitted at the same time, I don't think that they're providing all of the documents because, like, everything that we've been seeing, it looks like it's a lot of the filings from the plaintiff side. They haven't been showing a lot of the filings from Google's side, from the Department of Justice website, if I'm making sense. Or at least, if they are, I'm not processing that, to my understanding. Um, like, I understand that they are, they have published a lot of shit from the Google side in here, but what we've been looking at so far, if you pay attention to what we've covered, all of that documentation, is all from the plaintiff side filing, is what I'm saying. You know what I'm saying? So yeah, but I'm not entirely sure as to what appeal that this motion of plaintiffs appellees to dismiss the appeal is for, but I'm still extremely interested in it nonetheless. So we're gonna look at that now. And what we're just gonna do though, I think is we might. I think I'm. How much am I gonna read of this? Let me see. You know what? Fuck it. I'm reading this whole thing. Okay. If it was, yeah, we're gonna read it. We're just gonna do it. We're gonna do it. Alrighty. So fucking our introduction here, and this is the motion of plaintiffs appellees to dismiss the appeal, and regarding some dude named Brad Greenspan. I don't know who he is. So, okay, introduction. Plaintiffs appellees, the government, respectfully request that this court dismiss this appeal because appellant Brad Greenspan has not demonstrated Article 3 standing. Mr. Greenspan sought intervention, purportedly to help the government fix its case and present missing data and info. While the United States values, invites, and routinely encourages the participation of third parties impacted or involved in the legal or factual issues presented by a litigated matter through a range of mechanisms, the limited question posed by this appeal is whether this particular third party has standing to intervene pursuant to the requirements of Article 3 in the Federal Rules of Civil Procedure. Mr. Greenspan's general interest in this litigation does not confer Article 3 standing for intervention of right and does not warrant permissive intervention. Statement. The government alleges that defendant appellee Google LLC has illegally monopolized certain markets for search services and search advertising in violation of Section 2 of the Sherman Act. Specifically, since at least 2010, Google has maintained monopolies in these markets through exclusionary conduct that deprives rivals of the scale necessary to compete effectively, discourages competition from potential rivals, and forecloses rivals through exclusive distribution agreements. These agreements include agreements with Apple Inc., with manufacturers of Android mobile devices and wireless carriers, and with third-party developers of web browsers, whereunder Google agrees to share advertising revenue with its counterparty in exchange for placement as the default search engine. Additionally, the government plaintiffs in case number, I don't think I can cite this right, allege that Google has also harmed competition through its operations of its SEM tool, SA360, which, what they mean Smart Ads 360, I believe, which is enabled by the impact of the exclusionary distribution contracts and general search engine rivals resultant in limited ability to attract advertisers. They further allege that as Google's monopoly flows downstream, Google's rivals are weakened in their ability to make arrangements with other industry partners that would increase their ability to attract users and build scale. And then it says here, case number, I definitely cannot cite this right, was filed on October 20th, 2020. Case number, sure shit can't cite this right either, was filed on December 17th, 2020. The parties conducted discovery for almost 2 years. The district court granted partial summary judgment to Google on August 4th, 2023. The trial commenced on September 12th, 2023, and concluded on November 16th, 2023, with a total of 42 days of trial. The parties filed post-trial pleadings on February 9, 2024, with further briefing due on March 22, 2024, and closing argument scheduled to begin on May 1, 2024. On the day the trial concluded, and more than 3 years into the lawsuit, Mr. Greenspan filed his motion seeking intervention, apparently both as a matter of right and by permission. Mr. Greenspan claimed to be able to contribute facts about specific matters beginning in 2005 related to Google and the state of play. And then they cite something else here that I'm not sure what the fuck this is. And then it says, without identifying any facts relevant to the government's case. He stated that he was happy to help the DOJ and states with fixing their legal case before too late by providing factually missing data and info that would help the case. Again, without identifying any relevant facts, he also appears to have requested that the district court ordered the government to bring additional unspecified claims against Google. On November 28, 2023, the district court denied Mr. Greenspan's motion for intervention. The court held that Mr. Greenspan had not demonstrated that he was entitled to intervene either as a matter of right or permissively. It explained that although Mr. Greenspan argued that he would contribute additional evidence in support of plaintiff's case, he had failed to identify any cognizable claims or injuries he would be able to pursue or remedy as required to establish Article 3 standing. Moreover, the court held that Mr. Greenspan's motion was untimely given the time elapsed since the inception of the suit, the purpose for which intervention is sought. The need for intervention as a means of preserving the applicant's rights and the probability of prejudice to those already parties in the case. You know what would be great? If they told us who the fuck this dude was, because I don't know, man. Maybe I'm gonna have to look into that. I might. We'll see. If I don't feel like I'm satisfied, I might. Okay, so on December 27, 2023, Mr. Greenspan filed a motion for reconsideration of the district court's denial of intervention. Mr. Greenspan stated that he was about to submit evidence regarding alleged illegal no-poach agreements, which were per se violations of the Sherman Act, apparently involving Google, Apple, Comcast, and MySpace, and an alleged illegal Clayton Section 8 violation, apparently involving Google and Apple. Okay. You know what? All right. Now this ties back the MySpace live stream with the Google monopoly. So you know what? Worth reading. That's actually how I literally got into this whole fucking case. So yeah. Okay. And then it says, the district court denied the motion on January 9, 2024. The court concluded that Mr. Greenspan had identified no intervening change in law, new evidence, or other reason for this court to reconsider its prior decision. The court further concluded that nothing presented in his motion in his motion alters the court's conclusion that he lacks Article 3 standings to intervene and that his application is untimely. On January 10, 2024, Mr. Greenspan filed a notice of appeal from the district court's order denying his motion for reconsideration, So I wonder if he was fucked over by Google in some other way and he was trying to get his shit heard. I literally don't know. I'm speculating right now. I don't know who the fuck he is. I don't know what the fuck he tried to do. I'm just reading this fucking document and I don't even know why. You know what I'm saying? Okay. So here we go. And then it says, Mr. Greenspan filed additional motions, including motions to recuse the district court judge, to recuse a separate district court judge not assigned to these matters, and to join multiple parties, including counsel for Google and for third parties, which the district court denied on January 25th, 2024. The court also ordered that, in light of the court's denials of intervention by Mr. Greenspan and his history of frivolous, repetitive filings, the clerk of court is hereby directed to accept no further filings from Mr. Greenspan in this matter, absent leave of court. So, in other words, they were basically like, you're a liar, bitch, fuck you, stay the fuck out of here. I'm just kidding, but is that pretty much what they said in legalese? Or, okay. So then the argument says, Mr. Greenspan has failed to establish Article 3 standing as required for intervention of right, and this court has declined to exercise jurisdiction over appeals of the denial of permissive intervention where the movement lacks Article 3 standing. Accordingly, this court should dismiss Mr. Greenspan's appeal. This court has jurisdiction over the appeal of denial of intervention as of right in Endangered Species Act, Section 4, deadline litigation. Oh, okay, they're citing some shit. Oops, I'm bad at citing that. All right. And then it says, a party seeking to intervene as of right must demonstrate that it has standing under Article 3 of the Constitution, from Fund for Animals, Inc. versus Norton. Then it says, the irreducible constitutional minimum of standing contains 3 elements. Lujan, I don't know if I said that right, versus Defenders of Wildlife. Specifically, a party must show they have suffered a concrete and particularized injury in fact that was caused by or is fairly traceable to the actions of the defendant and is capable of resolution and likely to be redressed by judicial decision. Food and Water Watch Inc. versus, is that Vilsack? Close enough. And then it says, see also Grassroots Policy Strategies versus FEC. The party invoking federal jurisdiction bears the burden of establishing these elements. Lujan, something else. See also Spokeo Inc. versus Robbins. This court reviews a district court's decision on standing de novo in Endangered Species Act. I think they mean, I'm pretty sure if I remember correctly, that de novo means like that you don't take into consideration other shit, that you're taking a case on its own as on a new slate, clean slate, kind of. Maybe that's wrong. I feel like that's bad. I don't know. Okay, so, and then it says, as the district court correctly concluded, Mr. Greenspan lacks Article 3 standing. His desire to help litigate this case and provide the district court with more information does not establish an injury in fact. An injury in fact is one that affects the party in a personal and individual way. Lujan. An interest shared generally with the public at large in the proper application of the Constitution and laws will not do. Arizonans for official English versus Arizona. See also Seegers versus Gonzalez. I have not been reading some of these quotations. Maybe I should have. Oh well. Mr. Greenspan's mere interest in the government's prosecution of this lawsuit does not give him direct enough stake in the outcome to establish his standing. Basically, they're like, you ain't got shit to do with this. What the fuck are you doing here, huh? Is that what's happening? Nor did Mr. Greenspan's oblique references to vague injuries, seemingly unrelated to the government's lawsuit, establish standing. And then some other shit. I'm really bad at reading the citation stuff. I'm definitely just going to skip through there. And it says, He has failed to specify any concrete injury that is fairly traceable to Google's conduct challenged by the government or that would be redressed by a favorable decision. Something about Lujan. And Reno Physicians Association, U.S. Department of Health and Human Services. Okay. Because Mr. Greenspan has failed clearly to allege facts demonstrating that he is a proper party to invoke judicial resolution of the dispute and exercise of the court's power, he does not have standing to intervene of rights in this matter. And then it says there is no reason for this court to review the district court's denial of permissive intervention. The denial of Rule 24B motion for permissive intervention is not usually appealable in itself, although the court may exercise its pendent appellate jurisdiction to reach questions that are inexplicably intertwined with ones of which this court has direct jurisdiction. From Defenders of Wildlife versus Perkiasa? I don't know. Although this court has observed that it is an open question in this circuit whether Article 3 standing is required for permissive intervention, it has declined to review the denial of a Rule 24B motion once it determined that the potential intervener lacked standing. Additionally, because for all relief sought there must be a litigant with standing, an intervener must demonstrate Article 3 standing when it seeks additional relief beyond that which the plaintiff requests. Town of Chester, New York versus La Rose State Inc. Because Mr. Greenspan has not established Article 3 standing, the court should follow its practice and decline to reach the Rule 24B issue. But can't say this right. Is that Percocet? This reminds me of Percocet. And then it says, see also Yoka? Oh, I'm sorry, I don't think I said that right. Versus U.S. Department of Interior. In Re-Endangered Species Act, we think, oh, I don't know, shit. I'm not good at reading this legal stuff. Okay, I'm gonna skip that. The conclusion just says, Plaintiffs-Appellees respectfully request that the court dismiss Mr. Greenspan's appeal. Who the fuck is Mr. Greenspan? So, let's scroll back up. His full name up the top? Brad Greenspan. Who the fuck are you? So he launched MySpace. Okay. Oh shit, it's all connected now. It is all connected now. So that is so funny. So I was like, we got into this. If you go watch my first live stream that I covered on this, I got into this case because of a live stream where I was like, did Facebook kill MySpace? Because for me, that's how it felt, and that's what I thought. But when I looked into it, the articles that were coming out and the information I saw kind of, in my opinion, basically blamed Google for why MySpace died. And I didn't understand why. Between reading those articles and then processing facts of this case, I actually now can understand how fucking Google potentially could have fucking definitely impacted and influenced MySpace's ability to succeed. But I definitely do think there's more to it in regards to if MySpace itself was doing better with its user experience, I don't think that they would have lost. They may have still suffered in their ability to scale and grow, but I don't think they would have continued losing users if their user experience is better, but maybe I'm wrong for thinking that. But that's just like where my head goes. You know what I'm saying? Like I definitely can understand a certain level of attributing fault or I don't know, whatever, or some type of like an obstacle to Google in terms of its ability to prevent MySpace from being able to scale to a certain degree. But then on another level, because of the head start where MySpace had with the social networking and the community aspect, I also feel like if they had, done other decisions when it comes to the user experience of their platform, if they had been able to retain enough people, then they wouldn't have completely gone like as far obsolete as they became, in my opinion, if that makes sense. But maybe I'm wrong for thinking that, but that's just like where my head goes. You know what I'm saying? And so yeah, okay. Now knowing who Brad Greenspan, I'm so glad I actually looked at that document because now at first I was like, well, should I even like this doesn't have anything to do with Google. Should I even be fucking looking at this appellee document like after I started reading it was something that was going through my head. But then now I'm actually like really glad that I did fucking read this. I'm adding this link right now. In the description of this video just to make sure I don't forget. Okay, so now I'm really glad I did do that because I feel like it really does kind of connect how it all started for me from me finding out about this case to my ongoing coverage of it. Like it's all like it connects it. I don't know. Okay, I'm circling, spiraling. Let's keep moving on. So we covered that. Alrighty, is this the same? Do I need to even? Yeah, whatever. Okay. Yeah, I don't need both that. Alrighty. So next up, when I was going through the discovery and case management documentation, something else that I noticed, and we definitely don't have time, and I don't have the mental capacity to go through all of this, and I don't even understand like the legalese side fully, really. I just understand more of the marketing side. So that's kind of where I want to focus if I can. But because I don't understand the legalese, I don't really know what I'm looking at until I get there, kind of, you know what I mean, in a way, after I process it all. So, yeah, that's also been an issue. But what I believe is that most of what's happening here are different orders and reports in regards to the exchange of getting evidence or discovery from each other, as well as different reports as it relates to scheduling the legal deadlines and case court case things, whatever fucking words. You know what I'm saying? Like I think that's what's being filed here. You know what I mean? Basically, for the most part here. And so a lot of this shit is boring shit. Like it's important shit to have filed, you know, or whatever. But I don't fucking feel the need to go through it because yeah, we get it. This shit was scheduled and then it happened, right? However, I noticed some interesting stuff. So here we have a memorandum in support of plaintiff's motion to sanction Google and compel disclosure of documents unjustifiably claimed by Google as attorney-client privileged. Now, in our previous material, or we went over the trial material, went over those slide decks, those fucking that came out with some evidence as it relates to where I believe the plaintiffs were able to reasonably argue that Google did misuse the concept of attorney privilege to try and make things undiscoverable, which should be discoverable and should not technically be covered by attorney-client privilege. In terms of there was an instruction for anything related to certain projects to be labeled with the subject line attorney-client privilege, which is, in my opinion, a bit suspicious, but that's just my opinion. And that's if I'm interpreting everything correctly. I'm not an attorney, so perhaps I didn't interpret all of that legal documentation correctly, but that is just what I felt like happened from what I processed of it. You know what I'm saying? Um, yeah. So, fucking, let's look at this memorandum real quick. I'm definitely not gonna read this whole thing, but I'm gonna just read the introduction. I don't have it in me to read the full statement of facts and everything. We did get to cover some of that in the slide deck shows, you know what I'm saying? maybe I should. Maybe I'll do like, maybe if I feel the need to, I'll keep doing different live streams where I do like readings, fuller readings of these documents perhaps. But, um, I don't think I have it in me to. Okay, so what we're just gonna do is read like this little beginning thing and the introduction. So, this is the memorandum in support of plaintiff's motion to sanction Google and compel disclosure of documents unjustifiably claimed by Google as attorney-client privileged. Plaintiffs respectfully request the court to sanction Google LLC, Google, for its extensive and intentional efforts to misuse the attorney-client privilege to hide business documents relevant to this case. Google has explicitly and repeatedly instructed its employees to shield important business communications from discovery by using false requests for legal advice. These efforts directly harmed plaintiffs, undermined their discovery efforts, and subverted the judicial process. The court should sanction Google and order the full production of withheld and redacted emails, wherein House counsel was included in a communication between non-attorneys and did not respond. Alternatively, the court should hold these silent attorney emails are not privileged and immediately order their production. So before we get into the introduction here, so if I'm understanding and processing right, not only did they, were they labeling things as attorney-client privilege and then sending them to the attorney for legal matters that they just didn't want to be made public, um, or was it really legal matter? I mean, is it legal matter if you're doing something that you know is illegal to cover it up? I guess so, right? And so they were sending these emails, they were sending them to the attorney, but the attorney never responded to anything. So, is that really attorney-client privilege? Or, so I see that. I see what they're doing there. Yep. Yeah. So it's just like, is this really an attorney-client communication if the attorney isn't involved in the communication? If the attorney's not communicating? Hmm. Because what legal advice did they get? Okay, and then we're going into the introduction here. It says, um, you know what? I should do a bigger window. So, yeah. Going into the introduction. For almost a decade, Google has trained its employees to use the attorney-client privilege to hide ordinary business communications from discovery in litigation and government investigations. Specifically, Google teaches its employees to add an attorney, a privilege label, and a generic request for counsel's advice to any sensitive business communications that employees or Google might wish to shield from discovery. Google has referred to this practice as communicate with care. Documents produced by Google make the existence of this corporate strategy undeniable and demonstrate the prevalence of this practice throughout the company. As part of Google's larger efforts to shield documents from production, Google employees were expressly directed to add artificial indicia? I don't know how to say that right. Artificial indicia of privilege on all written communications relating to the exclusionary search distribution agreements at the heart of Google's monopolies. Google's employees followed the Communicate with Care training, routinely adding in-house counsel to business communications, affixing privilege labels, and including pretextual requests for legal advice when no advice was actually needed, sought, or thereafter received. In these email chains, the attorney frequently remains silent, underscoring that these communications are not genuine requests for legal advice, but rather an effort to hide potential evidence. Google's strategy worked. Google's outside counsel often accepted Google's employees' artificial claims of privilege at face value. After plaintiffs' extensive efforts to uncover and challenge erroneous privilege claims, I said Google's. After plaintiffs, did I say Google? I don't know. I'm just taking it from that, my bad. After plaintiffs' extensive efforts to uncover and challenge erroneous privilege claims, Google's outside counsel eventually deprivileged tens of thousands of documents initially withheld or redacted on the basis of privilege. These efforts, however, do not and cannot cure the misconduct inherent in Google's efforts to hide relevant communications. Indeed, many more challenged documents remain outstanding. Accordingly, the court should invoke its inherent authority to sanction Google and order the production of all emails between non-attorneys where the included in-house counsel did not reply. Alternatively, the court should hold that the Google has not and cannot make the necessary showing to support its privilege claims over any email created pursuant to the Communicate with Care program, and order Google to produce withheld the emails where the included in-house counsel did not bother to reply. These silent attorney emails lack all indicia of privilege and should be produced. Although Google's policy of pretextually including attorneys on business communications has affected a far larger set of documents that Google has withheld or redacted, and plaintiffs reserve their rights on this broader set of documents, immediate production of Google's silent attorney emails is the minimum relief appropriate given Google's abuse of the discovery process. Damn. Yeah. So this is the memorandum in support of plaintiff's motion to sanction Google and compel disclosure of documents. And I'm going to try to make sure I remember to link that at the end. Okay. So I'm pulling that up here so I remember to link it later. And then next up, other things were submitted here regarding everything, and in here they also went ahead and even submitted the plaintiff presentation, but it's like 186 slides or whatever. So yeah, I believe we went over this though, if I'm not mistaken. What do I think? I think we did. I'm not sure. If we didn't, I'll go over that in a different, if we didn't go over this, then I will go over this in a different stream. It all kind of blurs together. We went over so many slide decks. If we didn't go over that one, I'll go over that one in a different stream. But I think we went over that one already. But what I'm talking about, the one that I think we went over already, is the slide deck called United States et al. Versus Google LLC plaintiff presentation, redacted, from September 8, 2022. I don't think I said that right, but whatever. You know what I meant. Okay. So yeah, and then there's some other memorandums here, like the opposition to defendant Google's motion for summary judgment. And I think we read some shit related to we read the memorandum opinion on the summary judgment. So yeah, and then there's a memorandum in support of the United States motions for sanctions against Google and an evidentiary hearing to determine the appropriate relief. And then later after that, and that was in February 2023, and then in March 2023, they had a reply in support of its motion for sanctions against Google and evidentiary hearing to determine the appropriate relief. So I just think that is hilarious. And then in September 4th, 2024, there was a joint status report regarding remedy processings. Oh, proceedings, not processing, proceeding, whatever. And a plaintiff's proposed remedy framework from October 8th, 2024. So I'm not going to go, actually, what is the framework? Is this showing what they think should happen at the end? Okay, I don't have it in me to process this right now, so I will cover the remedy, either the remedy framework or whatever the court ruled or whatever. I might cover some shit like that. I might cover the remedy framework when I cover the court's ruling. I don't think we have the court's ruling yet, do we? We're still waiting on that, huh? Um, yeah, I think I'll cover that in a different, if I do cover that, I might not cover that, but if I do, it'll be a different stream. Okie dokie. Um, yeah, just seeing if there's what we want to cover, just, reviewing what we covered, seeing what else we want to cover. Okay. There are two documents, two more documents that I do think we're just going to look at. We're not going to look at all of these real quick, but there's the plaintiff's statement of genuine facts and their counter statement of material facts. I just wanted to check out the introduction for these real quick, and just see what the fuck they say. So the introduction for the statement of genuine issues, it says, plaintiffs respectfully submit this statement of genuine issues pursuant to Local Rule 7H of the U.S. District Court for the District of Columbia in support of their opposition to Defendant Google LLC's motion for summary judgment. This document contains plaintiff's response to each statement in defendant's statement of undisputed facts in support of its motion for summary judgment. Plaintiffs will set forth additional relevant material facts in a contemporaneously filed document. And it goes into first, let's see, let me double check here. Okay. And then it goes into overarching issues relating to Google's statement of undisputed material facts, and plaintiffs respond for purposes of this motion only. And I think I don't understand enough about the law to fully cover this. Actually, fully fact shit. I'm thinking they were going to sum up some goddamn facts for us in the introduction. Because I feel like sometimes, the introduction in the beginning. You know what? Fuck it. I'm just going to read these first two paragraphs real quick. Okay, I'm sorry. It says, first, overarching issues relating to Google's statement of undisputed material facts. First, there are often important discrepancies between A, the statements contained in some of the paragraphs in Google's SMF, and B, the statements in defendant's memorandum of points and authorities in support of its motion for summary judgment. Those paragraphs in the Google SMF allegedly support. Some statements in the Google SMF may be correct and correctly supported, but that statement is then cited in the Google SJ brief for a different or broader proposition that is disputed or is not supported by the statement or the corresponding cites to the factual record. Plaintiffs' responses in this document only address Google's SMF, and plaintiffs reserve the right to challenge all inconsistent factual statements in Google's SJ brief. In some instances, to assist the court, plaintiffs have noted this discrepancy. For example, plaintiff's responses to statements 15 and 206. I'm not going to go look into what those statements are and shit right now, because I don't have it in me and stuff, but I probably won't do that at all. But fucking, basically what I think they're saying is, we caught these bitches, if not lying, saying some things that where they are in one case saying one thing and another case saying something else. That's my interpretation of this shit, if I am understanding correctly of what could have happened here. And then it says, second, Google's SMF frequently makes overarching universal statements about the agreements they have entered into with browsers, original equipment manufacturers, OEMs, and other relevant parties, while citing only one or two agreements over a limited period in support. For example, Google claims in Statement 61 that Google and Apple have never entered an agreement that restricts Apple from integrating search engines other than Google into the Safari browser. However, in support, Google cites, and then it's redacted, and seeks to justify that incomplete disclosure with a disclaimer, and then some redacted shit here, and then it says, this is not an insulated error. Not insulated. This is not an isolated, goddamn, an isolated error, but one repeated dozens of times in Google's SMF regarding its contracts with counterparties. Google's reliance on example documents that do not cover the period of the statement violates LCVR 7H's requirement that Google include references to the parts of the record relied on to support the statement, and runs counter to the D.C. Circuit's direction that the moving party statement specifies the material facts and directs the district judge and the opponent of summary judgment to the parts of the record where the movement believes support his statement to adequately permit the opposing party the opportunity to respond. And it cites Gardels versus Central Intelligence Agency. For that reason, statements containing this type of inadequate support should be limited to the period covered by decided agreements, and before any amendments to those agreements. Where relevant, plaintiffs have identified these statements in their individual narrative responses. So yeah, for them to have said that they never entered into an agreement that restricts Apple from integrating other search engines, yeah, that's a lie according to the legal case. So like, ooh, damn. You know what I'm saying? So yeah, okay. Number 2, plaintiffs respond for purposes of this motion only. Any statement herein that is a fact is disputed, undisputed, or disputed in part is made for purposes of this motion only, and should not bind plaintiffs at trial or otherwise other than for purposes of this motion, nor limit plaintiffs' proof at trial at the materials cited herein. Okay. And then it cites some shit. I don't know. It's like I'm not good at reading any of that, so I'm not gonna. Okay. Okie dokie. Then I wanted to check out also, but I really don't know shit about this, and this is even longer, so I'm definitely not going to read that, I think. Is it even longer? I don't know, it's long. But there's also a counter statement of material facts from the plaintiffs as well. So I thought we could just check out the beginning. So there's, I don't know if I'm going to read, like, we'll see. So they have an overview of the markets and an overview of search defaults and pre-installations. And I kind of thought that those two things were kind of important. So let me just, shit, yeah, fuck it. We're just gonna read the, I think I'm just gonna, like, read what feels right from the overview of the markets regarding general search services for the market, search advertising, general search text advertising, scale, and general search services, as well as the overview of search defaults and pre-installation part. We're gonna read that, and then we'll just finish it there. Okay, so it says plaintiffs in both actions, captioned above respectfully, submit this counterstatement of material facts under Local Rule 7H of the United States District Court for the District of Columbia in support of their opposition to the motion for summary judgment filed by defendant Google LLC, defendant or Google. And then it goes into 1. Overview of markets. A. General search services market. General search services are offered by general search engines, which are one-stop shops consumers can use to search the internet for answers to a wide range of queries. General search services are a unique, relevant product market. A relevant geographic market for general search services consists of general search services provided to consumers in the United States. After a user enters a query on a general search engine, results appear on a search engine results page. Google search website, how results are automatically generated. Google and Bing are the only significant U.S. general search engines that crawl and index the web, while other U.S. general search engines syndicate results. The 2 leading U.S. general search engine companies today are Google and Bing, with smaller players including Yahoo, DuckDuckGo, Brave, Ecosia, and Neeva. Since 2010, Google has had an average annual market share of 80% or more in the U.S. market for general search services. In 2020, Google's share of the U.S. general search services market was nearly 90%, with an even higher share of 94% on mobile devices. Bing, Google's closest competitor, has a U.S. general search services market share of roughly 6%, and it has not exceeded a 10% market share since 2015. On U.S. mobile devices, Bing's market share is even smaller at roughly 1% in 2021, and it has not exceeded a 2% share since 2016. Now we're going into B, search advertising and general search text advertising. Most general search engines do not charge consumers a fee. When a consumer uses Google, the consumer provides Google data and attention in exchange for search results. Google monetizes a consumer's data and attention by selling ads served in response to the consumer's real-time query. There is a search ads market that consists of advertising that is displayed on the search engine results page that general or specialized search engines return in response to consumer real-time queries. There is a general search text ads market that is a narrower market wholly contained within the search ads market. There is a relevant geographic market for search ads served in response to queries from users located in the United States. There is a relevant geographic market for general search text ads served in response to queries from users located in the United States. General search text ads appear on the search engine result page of a general search engine and look much like the organic, non-advertising search result links. They consist primarily of text and contain little or no pictures or other graphics. Google has a market share of roughly 74% in the United States search ads market and has had a share of over 70% since 2015. Google has a market share of roughly 88% in the United States general search text ads market and has had a share of over 80% since at least 2016. Bing, Google's closest competitor, has held a market share of less than 9% in the market for United States general search text ads since 2016. Google earned approximately redacted in revenue worldwide from the sale of search ads in 2021. Google generated approximately redacted in operating profits worldwide from the sale of search ads in 2021. C. Scale in general search services. In the context of general search services, scale generally refers to the size of data a search engine cumulatively has access to when users interact with the search engine. Google's scale in the general search services market exceeds its rivals by many multiples. Then a bunch here is redacted. Since at least 2006, Google's employees have recognized that its scale gives it a significant competitive advantage. Even more is redacted here. Search engines rely on continuous flows of user data to improve search quality, including ranking, search features, and the ability to experiment and innovate. With every query, Google gives some knowledge and gets a little back. Then we give some more and get a little more back. These bits add up. And then a bunch here is redacted. And then it says, in general search, user data fuels feedback loop that affects product quality and competitiveness. And then it redacts some shit. Then it says, Google's scale advantage is particularly significant on mobile. Google dominates the search landscape, particularly on mobile, with 95% market share. Google's global market share across all platforms as of August 2019 was 92%. Almost a third of all mobile searches are related to location. Then we got some redacted shit. It says mobile queries are substantially different than desktop queries. More redacted shit. Mobile queries often have a location component. More redacted shit. Desktop user data is not a full substitute for mobile user data because user data, including search intent and interaction patterns, are substantially different when the consumer is searching on a mobile device than when the consumer is searching on a computer, such as a desktop or laptop. Redacted stuff here. Google's scale advantage is particularly significant for answering tail queries. Tail queries are queries that occur rarely on general search engines. Redacted. Then it says a long tail concept would be one that in our query stream as a whole, regardless of how it is processed, it's a concept that's not often mentioned. For example, a popular celebrity would be not a long tail concept. It would be a sort of a more, people call it a head concept, or a short tail keyword. On the other hand, like an obscure telegraph system from 1925 or something like that might be a long tail concept. The thing about long tail keywords and long tail concepts are searched for less than short ones, but they have a higher intent behind them typically, which is why they can also lead to higher conversion, but there's just less searches for them. And then it says, tail queries and mobile queries tend to overlap because, like tail queries, mobile queries tend to seek uncommon, granular, location-based information. Then it goes into redacted stuff here, which says, access to user feedback for tail queries has a substantial effect on improving the search quality for tail queries. Redacted. Then it says the scale gap between Google and its competitors makes it difficult for the competitor search engines to match Google's search quality. Redacted here, of course. Then it says the scale gap between Google and its competitors makes it difficult for the competitor search engines to compete for users, such as increasing scale. And then it's redacted. Then it says, because of diminishing returns to scale, Google benefits less from additional queries than its rivals. Redacted here too. Then it says, search engines with greater scale attract more advertisers. Redacted stuff. Then it says, question. So does the fact that Google has more users and more queries make the platform more attractive to advertisers? Answer, yes. Question. And is one of the reasons advertisers don't purchase more text ads or search ads on Bing because it doesn't have as many queries or users? Answers, yes. Question. So is scale an important factor that advertisers consider when picking a search advertising platform? Answer, yes. And then we have redacted stuff here. Then it says, the more volume we have in the marketplace, you think more advertisers will be attracted to the marketplace in general, and that will increase the RPM. And then it says, it's redacted. It says, having more user-side data, that is more scale, allows search engines to better monetize ads. Redacted here. It says, Google presentation, search ads bootcamp. Day one. Oh, okay, my bad citing stuff. I'm bad at reading that. Redacted here. It says greater scale tends to increase advertising revenue. Redacted shit, redacted shit. It says there is a belief that as we improve the overall search experience, there is hope people come back to Google overall better, more often. So if we target overall growth, for instance, a search gets faster. If we are providing a better user experience, then people come back to us more often. And that includes for things like commercial queries. Redacted stuff here. And then it goes into earning more from each query allows search engines to pay more for distribution deals. This allows search engines to secure distribution on browsers, desktop computers, and mobile devices, which in turn serves to capture even more search queries for the feedback loop. With less revenue, rivals are predictably less able to invest in quality improvements that benefit consumers and advertisers. Redacted stuff here. And then we're going into item number 2 here, overview of search defaults and pre-installation. The most common way users access general search engines is through pre-installed search access points. A search access point is a place on a device where a user can enter a search query. In 2005, OEMs had little interest in distributing Google search without financial incentives. In 2005, OEMs demanded revenue share to distribute Google Search. Being the preset default search engine for a search access point on a pre-installed and prominently placed app is the most efficient and effective way for a search engine to reach users. Then we're going to redacted stuff here. And then it says, Google admits that attaining a pre-installed search access point, depending on the setting, can encourage utilization of a service. In the United States, device distributors, such as Apple, OEMs, carriers, decide what apps, and therefore what search access points, to pre-install, and where to place those apps on their devices. Before a device is sold to the consumer, a given pre-installed search access point on the device can be assigned a preset default search engine to which it will send queries entered by the consumer. And then it's redacted here, and then it says, when a user purchases an Apple iPhone, it comes with Apple's Safari browser pre-installed, which has Google as the preset default search engine for queries that users enter in the URL address bar. Most consumers stick with the preset default search engine that is assigned to each respective search access point on their device, also known as the default out of the box. Redacted shit. Then it says, consumers rely on habit in searching the internet. Given that consumers carry out these searches using familiar interfaces and devices, and that these searches provide immediate feedback, user search patterns become strongly habituated. Consumers often do not make, or even know that they can make, an explicit choice about which general search engine to use for a given search access point. And then it's redacted here. Then it says, even where search users might want to change the preset default search engine for a given search access point, the effort and complexity involved with switching, referred to as choice friction by plaintiffs. Expert Professor Antonio, is that Rangel? I don't know how to say that, PhD, biases users to stick with the default option. Google's chief economist, Hal Varian, regularly reminded Google employees of the power of defaults. Search defaults drive user traffic. I'm not good at this. Default status generally will lead to some increase in usage. Search defaults for search access points tend to be stickier on mobile devices than on PCs. Redacted stuff here. Google routinely hires or contracts with behavioral economists to consider the impact of defaults. Some other stuff here I'm not good at reading, some other shit redacted here. Users are unlikely to switch away from a device's preset default search service. Bing's share of search queries is much higher on devices, where it is the preset default search engine for search access points. In Russia, Google's agreement with regulators to introduce a search engine choice screen on Android devices caused Google's share of Android searches to decline. Paying to have Google as the preset default search engine for search access points is the highest cost but highest value way to acquire users. Organic downloads, paid marketing, and at promotion integration do not match the likelihood of success that being the preset default search engine has in getting consumers to use Google's search engine. Google's revenue share payments to device and browser distributors enable Google to reach more users. Reaching more users is a key part of Google's consideration for the revenue share payment. If rivals won the defaults currently secured by the challenged terms of Google's distribution agreements, of Google's United States general search market share would shift to rivals. Oh, it's a redacted. I'm guessing that's a redacted percentage. And then the next part is redacted, and it's about revenue share agreements though, because it says under its Android RSAs, and then it's redacted. And then it says, the size of the default effect is likely smaller on Mozilla's Firefox browser than in other contexts because Firefox is a non-default browser, necessarily used only by people who are technologically savvy enough and motivated enough to override Windows default. Okay. And so, related to the counterstatement of material facts, we went through and just read about the overview of markets and the overview of search defaults and pre-installation because I think that gives a bit more context into the background in terms of what was happening in some ways a little bit externally and internally, but with how some of the things that happened enabled them to monopolize. I also feel that when we move into item number 3 here, Google's distribution agreements, that's also extremely relevant to this. However, I don't have it within me to go into all of that shit. So the distribution agreements, to sum that up in a nutshell, they were basically locking them in to exclusivity. To basically, they found ways to make it so their operating systems or their ability to put apps and things like that out there for everybody, for like Android, was contingent on them maintaining their deals. That's what happened, in my opinion. A poor, rough summary in a nutshell is what happened with Android. And then a similar kind of thing happened with like Apple, but except for it was just related to like Safari browser with Google, so it's like all like related. It's different but kind of similar, basically, in a nutshell, but as it's related to each specific company involved, you know what I mean? Yeah, poor summary there. So yeah, that for now sums up my legal documentation coverage from the United States and the Plaintiff State versus Google LLC from the Department of Justice, from the Antitrust Division, as we're going to be covering it in this particular live stream. But I will be looking at, so there's a memorandum in support of plaintiff's motion to sanction Google. I need to remember to link that in the description of this video because we did go over that. But there's also the United States et al. Versus Google LLC plaintiff presentation. That one, I don't remember if we covered it or not. If we did not cover it before, I might cover it in the future. And then the last but not least, third thing, the proposed remedy framework. I want to look at that. I might cover that, but I might wait to cover that if I do to when the because I don't believe that the official, I know that the court did rule that it was a monopoly, but I don't think that the court ruled on the there's the appeal and things like that could be happening. So I don't know if there's an official ruling on what is the actual remedy taking place going to be, if that makes sense. I don't know the correct legal words, and perhaps that has been stated and I didn't process it yet, but yeah, so either way, I'm going to wait until either that comes out or I've processed it if it's out already. I said I'm going to wait, for the captioner, it got it wrong. I said I'm going to wait until either the information about the remedies come out or I process what has come out if it's out already for what's final there. And then I will cover the proposed remedy framework with that together is what I'm going to do. So for now, that sums up our coverage for the legal, I said sums up our coverage for the legal documentation for today. Next up, we're going to move into the news coverage as it relates to this case. And so before we do that, what I am going to do is just take a quick little break, just reset a little bit because, reading, if I read so much, I feel like I just start getting tongue-tied and stuff. So I'm going to give myself a little break. I'm going to be back in about 20-ish or so minutes tops. And then we're going to continue going through some of the news coverage that has come out about this case so we can continue processing all of that together. So yeah, thank you so much, and I will be right back. So now we are back. So next up, what we are about to do is get into our news coverage here. And starting off, I have an article from TheVerge.com, and it was written by, I don't know if I'm saying this right, but is it Adi Robertson? And so the title is U.S. versus Google, all the news from the search antitrust showdown. Let's see, is there a better way to, I will zoom in on this. Okay. Yeah. So we're gonna zoom on in on that a little bit. And before we hit here, I just want to remind you guys, if you're near Pasadena, Texas, near Houston, Texas, and you're considering getting a tattoo, check out Ink by Cast Tattoo near the VHO Studio, at the VHO Studio. I can't speak. Read my mind. So, first up here, we have United States versus Google, all the news from the search antitrust showdown. And this was written October 17th, 2024. And it says, on August 5th, Judge Mehta, am I saying that right? I don't know if I am. Let me see. It says on August 5th, Judge Mehta ruled in the case of United States of America versus Google, saying the court reaches the following conclusion. Google is a monopolist, and it has acted as one to maintain its monopoly. It has violated Section 2 of the Sherman Act. That ended the biggest tech antitrust trial since the United States took on Microsoft in the 1990s. Possibly aside from the government's antitrust case targeting Google's ad business. But it's also just the start of the process. Oh, so there is a different one relating to the ad business, and this one's related to the search. Oh. Okay, you know what? We're gonna read this one too. Fuck it. But it's also just the start of the process, is what it says. Now, lawyers for Google and the Department of Justice are arguing over the ruling, as well as what to do about the company and its products. The Department of Justice argued that Google struck anti-competitive deals with Apple and other companies for prime placement of its search engine. Google maintains that its dominant market share is the result of a superior product. The Department of Justice says options to resolve the situation include breaking up Google to separate products like Chrome, Search, and Android. But it may be a while until we hear about their full plan. And so here we can, they have more updates and notes from the case linked here as well. And the highlights of this include how the Department of Justice wants to break up Google's search monopoly. There's no price Microsoft could pay Apple to use Bing, the spiciest part of the Google antitrust ruling. Now that Google is a monopolist, what's next? Judge rules that Google is a monopolist in the United States antitrust case, breaking down the Google antitrust trial. The antitrust trial against Google search starts today. Here's what to expect. And those are their previous coverage that they've done on here. So yeah, and then also, not related to this case, but very interesting to me, October 17th, Emma Roth published in The Verge the headline, Google is replacing the exec in charge of search and ads. Does that look like a scapegoat, or am I just overthinking it? Oh, so Prabhakar Bhagavan, I don't think I'm saying this right, is now going to take on the role of chief technologist. Oh no. And I'm saying oh no because I'm like, if he, like, in my head, it's just like, is he going to be a scapegoat next? I don't know what's happening, but whatever. Okay, And so here's an update from The Verge. I might cover some of these highlights here in a different stream. But for now, let's move on. They also have another article here that I need to remember to link later. It says US versus Google Redux. All the news from the ad tech trial. Also from The Verge, published October 22nd, 2024 by Lauren Feiner. Feiner? I don't know how to say that. Alrighty. And then it says Google and the Department of Justice are facing off again. This time in a trial about whether Google has a monopoly in advertising technology markets. The trial started on September 9th in a federal court in Alexandria, Virginia. The Department of Justice argues that Google has unfairly locked up the market for ad tech tools that publishers and advertisers rely on to monetize their websites and market their goods. Google retorts that it's created efficient products that work well for customers and says it faces plenty of competition. The trial comes on the heels of a historic ruling in favor of the government in a different antitrust trial against Google before a different judge. A DC District Court judge said Google had illegally monopolized the online search market. Okay, so now I see. So it is two different cases. Okay, so last live stream, I thought that it was one case. Now I'm realizing there are two different cases, but the search case also does involve ads, which is why I was getting confused. Okay, light bulb, it all makes sense now. I will go try to add like a little disclaimer in the description of that video and try to make sure I'm clearing that up going forward, I believe. So I was previously confused about if there are two different court cases related to the search monopoly and the ad monopoly, or if it was one case. After I was reading the initial complaint, because of everything in the initial complaint, I thought the initial complaint related to both the search and the advertising monopoly. From this article from The Verge, we can see here it looks like there are definitely two different cases here, and that the one that I was reading seems to have been more focused, the one that was more focused on the search aspect, as we understand, and that makes perfect sense from what we've been reading. It just also relates to the advertising because they're connected, because of how Google set it up. So now I see that. And then there was another case that covers the advertising side as well. Okay, that is what I believe now, from what I processing of The Verge here. So yeah, did I finish reading this? I don't think I did. It says, a DC District Court judge said Google had illegally monopolized the online search market. So while the ad tech case proceeds, the government is simultaneously contemplating what kinds of remedies it will ask for to restore competition in search. Okay, there we go. So the government has not asked for the remedies yet. And so, or they didn't as of October 22nd. Or was this 22nd? Yeah. Okay. And then the highlights here, which I believe I might potentially be covering in a different live stream, because I think that would actually be very helpful for me. If I actually do cover the two highlights of these two articles, I think that will help me process the differences in these cases. So all of the legal documentation that we've been reading so far has been as it relates to the search ads, the search case particularly. There's also a different one as it relates particularly to the advertising case. I believe, if I have that correct, if I understand correctly, I think that's how it is. Okay, so our highlights here. Why Google is back on in court for another monopoly showdown. Google employees' attempts to hide messages from investigators might backfire. In US versus Google, YouTube CEO defends the Google way. How Google altered a deal with publishers who couldn't say no. Google and the Department of Justice's ad tech fight is all about control. Google and the Department of Justice return for round 2 of their antitrust fight, this time about ads. So yeah. Ooh, and then another headline here from Lauren Feiner, October 22nd. It says, tech critics want a Google exec punished for deleted chats. Yeah, ain't that interesting? Ain't that interesting? Okay, I think I might have to come back and cover the highlights from The Verge here in a different live stream. So from NPR, from the Department of Justice, I can't speak, what am I saying? From NPR, we have another article, and this was written October 9, 2024. I keep saying 2024 wrong. I don't know why. And 2022, I say that wrong too. Whatever. Okay, y'all know what the fuck I mean. The headline here says, Justice Department calls for sanctions against Google in landmark antitrust case. And it's written by, so my little sister's name, we say it Dara, but I've also met people who say it Dara. So I don't know if this is a Dara or a Dara, but it's written by either Dara or Dara. I'm sorry, care. Maybe it's Dara. Am I wrong? I'm sorry. Okay. Dara Kerr. Shit. I don't know how to say her first or last name. My bad. I'm so sorry. Okay. And then it says, the Department of Justice is proposing a series of sanctions against Google to ensure that it can no longer monopolize the search engine market. In a filing late Tuesday night, the government laid out its framework for reining in the tech giant. Proposals include possibly putting an end to exclusive agreements Google has with companies like Apple and Samsung, and prohibiting certain kinds of data tracking. The government wrote that it's considered behavioral and structural remedies that would ensure Google couldn't use its Chrome browser or Android phone in a way that advantages its search engine, but didn't outline what the structural remedies would be. Google's anti-competitive conduct resulted in interlocking and pernicious harms, reads the filing. The markets Google controls, it continues, are indispensable to the lives of all Americans, whether as individuals or as business owners, and the importance of effectively unfettering these markets and restoring competition cannot be overstated. The 32-page filing follows federal judge Mehta's ruling in August that Google had acted illegally to maintain a monopoly on the search engine market. That ruling was the culmination of an antitrust lawsuit that the Justice Department filed against Google in 2020, which is joined by 38 state attorneys general. The Justice Department accused Google of illegally orchestrating its business dealings to ensure its search engine dominated the market. After a 10-week trial last fall, Mehta ruled in favor of the Justice Department. Google has said it will appeal this decision. The government's filing on Tuesday is its initial set of proposals to seek remedies against Google. In the filing, the Justice Department said it intends to go through court-ordered discovery for further evidence to support its stance. It will file a more refined framework in November, and Google will have a chance to propose its own remedies in December. In a blog post published Tuesday night, Google's Vice President of Global Affairs, Leanne Mulholland, wrote, "We are concerned that DOJ is already signaling requests that go far beyond the specific legal issues in this case." Mulholland appears to be interpreting the government's filing as calling for the breakup of Google's Chrome and Android businesses. She argues that those businesses have cost the company billions to develop. They are free and have open source code that has benefited competitors and customers, she wrote. Make no mistake, breaking them off would change their business models, raise the cost of devices, and undermine Android and Google Play in their robust competition with Apple's iPhone and App Store, she continued. This is a major turning point in the regulation of big tech. Monopolies aren't illegal in and of themselves, but using monopoly power to maintain market dominance is against the law. The last antitrust case of this magnitude to make it to trial was in 1998 when the Justice Department sued Microsoft. That lawsuit centered around claims that Microsoft illegally grouped its various products together in a way that both stifled competition and compelled people to use its products. A judge ruled in favor of the Justice Department back then, saying Microsoft violated antitrust laws and held an oppressive thumb on the scale of competitive fortune. Over the last quarter of a century, tech companies have amassed enormous power and now play a crucial role in most people's daily lives. Google's parent Alphabet is one of the most valuable companies in the world, now worth more than $2 trillion. And the word Google is synonymous with searching the internet. The company controls around 90% of the United States search engine market, while its closest competitors, Bing and Yahoo, each have around 3% of the market share. If Meta agrees with the Justice Department and decides to put stringent limits on Google's reach, it could have a ripple effect throughout the industry. What the Justice Department wants from Google. The thrust of the Justice Department's case against Google focused on exclusive agreements the company made with device manufacturers like Apple and Samsung. During the trial, internal documents and witnesses revealed that Google had paid billions of dollars per year to ensure it was the default search engine on smartphones, like the iPhone, and on web browsers, like Mozilla's Firefox. Witness testimony revealed that eye-popping sums Google paid its partners. For example, in 2021 alone, Google spent a total of $26.3 billion on its deals to be the default search engine. Apple had the most lucrative partnership with Google, bringing in $18 billion from the search giant that one year, according to the New York Times. The government argued that these exclusive agreements made it difficult for rivals to edge in and left consumers with fewer choices. Google's lawyers argued these were agreements that the search engine's partners chose to enter on their own accords. The Justice Department wrote in its Tuesday night filing that one of the remedies it's evaluating is limiting or prohibiting the agreements. Fully remedying these harms requires not only ending Google's control of distribution today, but also ensuring Google cannot control the distribution of tomorrow, the filing states. During the months-long trial last year, Google argued that its search engine is the most popular because it is the best product out there and that people prefer it. When Google CEO Sundar Pichai testified, he said paying billions of dollars to ensure its search engine is the default made sense. So why would you have to pay billions of dollars to be the default if you are the most popular because you're the best product? Just a question for the class. I don't think I'm saying this dude's name right, but we're going to keep going. We want to make it very, very seamless and easy for users to use our service, Pichai said. The search engine, DuckDuckGo, is a much smaller rival to Google. In a blog post last month, CEO Gabriel Weinberg wrote that restricting Google's exclusive contracts would level the playing field. Google likes to claim everyone chooses Google, Weinberg wrote, but most consumers don't. They just go with the default. In its filing, the Justice Department says it's evaluating other remedies, such as controlling how much data tracking. Why do I keep saying data tracking? Like, what the fuck is that? It's data tracking. Like, what is wrong with me? Okay, such as controlling how much data tracking Google carries out online. The government says the tracking raises genuine privacy concerns that could not only harm users, but deny scale to rivals. Additionally, the Justice Department evaluated Google's advertising business and said it's considering remedies that would create more competition and lower the barriers to entry. Once the Justice Department and Google issue further proposals in November and December, another trial will take place next April. Meta will also preside over that case and will hear both sides as they argue their cases for possible remedies. Google just wrapped up the bulk of another trial brought by the Justice Department over its advertising business, in which the government alleged that the company illegally controls ad tools for publishers and advertisers. Okay, I'm sorry. It was linking to that. I clicked the link that it linked to for it said wrapped up the bulk of another trial, but it links back to that Verge post that I wanted to recover before, that I read before, and said I wanted to cover more of later. So we'll go back to that. I apologize. I'm going to keep going. Closing arguments for that case are expected in November. I need to get on covering this too. Oh shit. And then it says, the U.S. government has targeted several other big tech companies in antitrust cases. Over the past few years, it sued Amazon, Apple, and Facebook parent Meta, which owns Facebook and Instagram, over business practices the government says hurt both rivals and consumers. In its case against Google, the government used the 1998 Microsoft suit as a blueprint. Bill Kovacic, shit, I don't know how the fuck to say that. Bill Kovacic, close enough. An antitrust law professor at the George Washington University Law School and a former chair of the Federal Trade Commission, told NPR in August that the Justice Department's win against Google could pave the way for other lawsuits. It establishes a foundation for obtaining a notable remedy in this case involving Google, he said, and it gives momentum to the Department of Justice and Federal Trade Commission prosecutions of other major tech companies. Boom. So yeah, in an editor's note, Apple Card and Apple News are among NPR's financial supporters. Interesting. It's all connected. Well, at least they disclosed that. Okay. So, moving on here, we have an article from the Dispatch, and it is headlined, The Antitrust Case Against Google's Ad Business Explained. And it says the government's latest case against the tech giant centers on its alleged dominance of online advertising. It was written by Nick, I think this is said Hafen, I don't know how to say his name, Nick Hafen. It's published October 3rd, 2024. It says, last week, Google concluded its, I don't know, let's pull this. Can we make this a little bigger? I apologize. How that? Let's see here. It's zoomed in still. That doesn't work. Let me zoom in this way. There we go. A little better. Alrighty. It says, last week, Google concluded its defense in United States versus Google LLC, a case brought by the Justice Department accusing the tech giant of antitrust violations in its online advertising business, which accounted for $237 billion of the company's 2023 revenue of $307 billion. The parties will now file written summaries of the key facts in the case and present closing arguments in late November. The 3-week trial, which took place in a federal courthouse in Alexandria, Virginia, is part of a broader antitrust crackdown on Google's business practices. In August, a federal judge in Washington, D.C. ruled that Google's search business violated federal antitrust laws in a lawsuit initiated by the Trump administration's Justice Department. Last year, Google was found to have unlawfully monopolized its Play Store app marketplace in a suit brought by Epic Games, the maker of the popular video game Fortnite. On Monday, Epic sued Google and Samsung on related antitrust violations. Damn. Shit, we need to cover this too. Okay, I'm gonna go over this article, another one. Okay, I have that. And then it says, after closing arguments, Judge Brinkema, I don't know if I said that right, sorry, will make a ruling likely after several weeks or months. What comes next could result in big changes for Google that could affect the online ad industry at large. How does the online ad industry work? In the online advertising ecosystem, advertisers pay to display their promotional content, while publishers, such as mobile apps, search engines, and other websites, get paid to host these ads on their digital properties. While some advertisers and publishers work together directly, many online ad transactions occur through a complex, indirect auction system. On the buy side, advertisers typically manage their ads through advertiser networks. These networks aggregate ad inventory from multiple advertisers, allowing for more efficient distribution. On the sell side, publishers often used specialized ad servers to manage their advertising space, optimizing which ads appear where and when. Ad exchanges sit in between and provide a marketplace where advertiser networks bid in real time on available ad slots from publishers. Advertisers specify maximum prices they're willing to pay for particular ad placements or keywords, and the exchanges conduct automated auctions for each ad slot, often in milliseconds as a web page loads. This process, known as programmatic advertising, allows for precise targeting of consumers and, theoretically, efficient ad placement across the internet. What's Google's role in the online ad ecosystem? Google entered the online advertising market in 2000, initially serving ads exclusively in its search results. Over the following years, Google expanded its services by partnering with publishers to display ads on third-party websites, helping advertisers reach broader audiences. As its buy-side role in managing ad inventory grew, Google began offering sell-side services to publishers for managing their online advertising space. In 2008, Google acquired DoubleClick, an ad tech company that controlled 60% of the publisher ad server market. The acquisition, which included DoubleClick's small but growing ad exchange, made Google, in the words of the Department of Justice, the buyer, seller, and auctioneer of online advertising. The consolidation gave advertisers access to more ad slots across the internet and provided publishers with a wider pool of advertisers, but it also enabled Google to influence both sides of the market. Now, we've gone over this ad exchange graph regarding the sell side inventory and the buy side demand and the ad exchange. We went over that when we went through the Department of Justice slideshows. I forgot which one that is, but I will try to remember and then put that in the description of this video if I can. I'm writing a note. Okay, put that in the description of the video. Yeah, so I'm not going to read this all again because I did before, but there is a graph here. It is on the Google Ad Exchange with sell-side inventory and buy-side demand here. And then it says, Google began bundling its buy-side, sell-side, and exchange services. Publishers had to use Google's exchange and sell-side services if they wanted access to its ads network. According to the Justice Department's initial filing, as Google's market share of online advertising increased, it artificially inflated prices for advertisers. passing the inflated revenue minus the transaction fee for Google on to publishers, hooking them on Google's platform. Rival companies struggled to match Google's payouts to publishers. Google also configured its sell-side services to give its own exchange preferential terms, selling ad space to itself before making it available to other exchanges. As new ad technology cropped up, Google acquired some competitors, changed its contractual terms to disadvantage those competitors, and cut deals with companies like Facebook to direct more of their advertising to Google. The Department of Justice has alleged that this conduct violates antitrust law. In its defense, Google argued its practices benefited a competitive marketplace, creating tools used by others in the industry. The company also claimed the amount it takes from each transaction it facilitates is lower than the Justice Department alleged, and, in some cases, lower than the industry averaged. Additionally, Google claimed the Justice Department defined the relevant market too narrowly. Are you fucking kidding me? The narrow market, that was broad as shit. They said, the relevant markets that they defined were related. I forget the exact wording, so don't quote me on this specific word for word, but it was literally like some shit like the markets were as they related to the United States geographically, as well as to the search market and to the advertising market, right? Now, I don't know if this is about the other case that I haven't looked into yet, which I need to, but if it's about that one, it's like, are you fucking kidding me? That was so fucking bright. Like, what? Anyway, okay. And anyway, so then it says, economist Mark Israel, one of the company's experts at trial, testified that advertisers have moved more and more of their advertising dollars to social media platforms and away from the type of open web display ads at issue in the case. Google's vice president of regulatory affairs claimed 70% of online advertising is sold directly rather than through exchanges like Google's. Overall, Google explained that competition and innovation, rather than protectionism, motivate its practices. What's an illegal monopoly under federal law? The government has accused Google of violating Section 2 of the Sherman Antitrust Act, passed in 1890 to curb anti-competitive practices during the Industrial Revolution. The government has to prove not only that the company possessed monopoly power, the power to control prices or exclude competition in the relevant market, but that it acquired or maintained that power through exclusionary conduct rather than through superior products or business practices. The Department of Justice claims Google used its monopoly power to limit competition by acquiring competitors, preferring its own platform above those of its competitors, and bundling its services together. In an unsuccessful attempt last year to have the suit dismissed, Google asserted its actions were explained by its efforts to provide value to all participants in the ecosystem, publishers, advertisers, and consumers. Defining the relevant market is a key question in antitrust cases. A broadly defined market makes the government's case harder to prove. If the market were defined as quote-unquote advertising, the government would have to prove that Google had a monopoly over a market that includes billboards, direct mail, and television and radio ads. In this case, the government proposed 3 separate markets, all limited to online indirect sales in the United States, buy-side services to advertisers, sell-side services to publishers, and exchange services in between advertisers and publishers. Google argued that the relevant market should be expanded to include direct advertising, Google's closed advertising systems like Amazon's, as well as mobile, video, and social media ad markets. I love how they're trying to argue that the relevant market should expand so that way it doesn't only include just them. No, let's make other people the problem too here. Just kidding. And then it says, what happens next? If Google loses, the Department of Justice will recommend a remedy, and the judge will make a final ruling. The most dramatic remedy would be to break up the company or force the sale of certain parts of it. Some say a breakup could actually increase the aggregate market value of the business, as happened with Standard Oil in 1911. I'm coming back to this. Um, well, I guess like where they're trying to expand the market, I guess they could be arguing, well, if Amazon can be successful, then we're not a monopoly. I guess that's their thought process there. I don't know. And then where it comes to this part where they're talking about like increasing the market value of the business, perhaps it could in terms of the parts where people want to get involved in the parts that they have to dismantle. Well, theoretically, they might have to buy in, which would increase value for the stakeholders, right? So I guess that could be a fallout. I don't know. Anyway, so moving on, it says there are a number of lesser remedies. The court could prohibit certain restrictive contractual provisions or business practices, such as exclusivity. In Google's recent search engine antitrust case, experts speculated that Google could be forced to terminate its agreements, making Google the default search engine, or it might be forced to license parts of its search business to others. In Google's Play Store antitrust case, the judge is reportedly considering imposing changes to the company's App Store policies that will last at least 3 years. What does this case mean for the tech industry? Even if Google loses, the impact could be limited. Innovation and markets often move faster than litigation, and generative AI is already disrupting the online advertising industry. I fucking hate the AI thing for now. Maybe it'll get better or whatever, but for now, that thing, I've already been bitching about it, but I hate it. It doesn't even give me what I'm fucking looking for most of the damn time. You know what I'm saying? And then, even if it does give me the answer I'm looking for, when I'm trying to go look into further details, when I click the link it says that answer is from, that information is never in the fucking link that it links to, and that bothers me. It's like, what the fuck? Anyway, okay, it says, generative AI platforms haven't yet figured out how to incorporate advertising. And if those platforms siphon off a significant amount of traffic from search engines and other websites, ads in those places become less valuable. A Justice Department expert testified that Google has already abandoned all but one of the alleged anti-competitive practices. The industry could change significantly before Google has to actually implement any changes as a result of the case, especially if it appeals. The company has already vowed to appeal the August search engine antitrust verdict. Microsoft was ruled a monopoly in 1999, but appeals and settlement negotiations delayed enforcement until 2002, when the company reached a settlement with the Justice Department. How would the election affect antitrust enforcement? Earlier this year, before he became former President Donald Trump's running mate, Senator J.D. Vance praised President Joe Biden's FTC chair. I guess I look at Lina Khan as one of the few people in the Biden administration that I think is doing a pretty good job. Though antitrust policy has often been a point of disagreement between the Democrats and Republicans, the parties are now on similar paths. That's because they're two wings of the same bird. The federal government stepped up its antitrust enforcement efforts beginning in 2020 under the Trump administration. Under Trump, the Department of Justice filed a search engine antitrust case against Google, and the FTC filed another against Meta, Facebook at the time, alleging that its acquisitions of Instagram and WhatsApp were anti-competitive. The Biden administration continued prosecuting both cases and filed the Google AdTech case. The FTC and several states have filed additional antitrust lawsuits against big tech companies. If Kamala Harris were to maintain the Biden administration approach, there might not be a significant difference between a Harris administration and a second Trump administration on antitrust. I don't even want to think about that right now. Okay, we're going to keep going. However, the others say the FTC under a second Trump administration would be friendlier to mergers and acquisitions, which have received more scrutiny from the FTC and DOJ under the Biden administration. Harris's close relationship with Silicon Valley has led others to suggest she may be less vigorous than the Biden administration on antitrust enforcement. Attorney Karen Dunn led Harris's debate prep team and delivered the opening statement for Google the day before the September 10th presidential debate earlier this month, a connection now being investigated by the House Judiciary Committee. I wonder, I feel like you can probably, I'm making heavy assumptions about the political leanings of this author right now, but I'm gonna just keep moving. I don't know. Like, I just don't have it in me to process that right now. I'm gonna keep focusing on this case. So, next up from PBS, we have here an article that's headline that says Google faces another antitrust trial a month after its search engine was declared a monopoly. And this is written September 9th, 2024. And I believe this may be syndicated from Alexandria, Virginia Associated Press, or maybe I'm wrong with what they mean by this. I don't know. But okay, but it says, or should I zoom in here? Let's zoom in a little bit. Okay. 1 month after a judge declared Google's search engine an illegal monopoly, the tech giant faces another antitrust lawsuit that threatens to break up the company, this time over its advertising technology. The Justice Department, joined by a coalition of states, and Google each made opening statements Monday to a federal judge who will decide whether Google holds a monopoly over online advertising technology. The regulators contend that Google built, acquired, and maintains a monopoly over the technology that matches online publishers to advertisers. Dominance over the software on both the buy side and the sell side of the transaction enables Google to keep as much as 36 cents on the dollar when it brokers sales between publishers and advertisers, the government contends in court papers. They allege that Google also controls the ad exchange market, which matches the buy side to the sell side. One monopoly is bad enough, but a trifecta of monopolies is what we have here, Justice Department lawyer Julia Tarver-Wood said during her opening statement. Google says the government's case is based on an internet of yesteryear, when desktop computers ruled and internet users carefully typed precise World Wide Web addresses into URL fields. Advertisers now are more likely to turn to social media companies like TikTok or streaming TV services like Peacock to reach audiences. As you know what, my own opinion as a marketer is a lot of businesses highly rely on Google. So I don't know. I'm interested in where these numbers are. I don't know. And then it says, in her opening statement, Google lawyer Karen Dunn likened the government's case to a time capsule with a BlackBerry, an iPod, and a Blockbuster video card. I feel like they're just making shit up now. Like, what? That's not even, what the fuck are you talking about? Like, that's not the same at all. So if it's a time capsule, then are you saying that you're a time capsule, that you're irrelevant and obsolete? Like, what? Like, this doesn't make sense to me. Okay. And then it says, Dunn said Supreme Court precedents warn judges about the serious risk of error or unintended consequences when dealing with rapidly emerging technologies and considering whether antitrust law requires intervention. Okay, so if this was about something regarding AI, then I would get that analogy in terms of the fact that we don't know where the fuck AI is going. So, you know what I mean? So comparing like that to the other materials, it would be like, I feel like you can make some type of point there in relation to no one knows what's going to become obsolete or where the future's going to go or how the technology is going to go type thing. But as it relates to taking accountability for monopolization, I feel like that's like this straw man argument where you're just throwing out this other shit out there to like distract them from what the actual argument is. You know what I mean? I don't know if I'm making sense. But yeah. Okay. And then it says, wait, did I read this? I don't remember. I'm going to read it again. It says, then such Supreme Court precedents warn judges about the serious risk of error or unintended consequences when dealing with rapidly emerging technology and considering whether antitrust law requires intervention. She also warned that any action taken against Google won't benefit small businesses, but will simply allow other tech behemoths like Amazon, Microsoft, and TikTok to fill the void. According to Google's annual reports, revenue has already declined in recent years for Google Networks, the division of the Mountain View, California-based tech giant that includes such services as AdSense and Google Ad Manager that are at the heart of the case, from $31.7 billion in 2021 to $31.3 billion in 2023. The trial that began Monday in Alexandria, Virginia, over the alleged ad tech monopoly was initially going to be a jury trial, but governments maneuvered to force a bench trial, writing a check to the federal government. Wait, did I say but government? But Google maneuvered to force a bench trial, writing a check to the federal government for more than $2 million to moot the only claim brought by the government that required a jury. Damn, PBS.org must have some real evidence to be posting that too, huh? Let's read that again for processing. The trial that began Monday in Alexandria, Virginia, over the alleged ad tech monopoly was initially going to be a jury trial, but Google maneuvered to force a bench trial, writing a check to the federal government for more than $2 million to moot the only claim brought by the government that required a jury. Damn. Pay that shit off. Okay. And then it says, the case will now be decided by By U.S. District Judge Leonie Brinkema. Brinkema? I don't think I'm saying that right. Who was appointed to the bench by former President Bill Clinton and is best known for high-profile terrorism trials, including that of September 11th defendant Zacharias. Well then. I love how it's not terrorism when the United States does it to other people, but it's only terrorism the government feels it's done to the United States. Got it. Okay. It says, Brinkema, though, also has experience with highly technical civil trials, working in a courthouse that sees an outsized number of patent infringement cases. The Virginia case comes on the heels of a major defeat for Google over its search engine, which generates the majority of the company's $307 billion in annual revenue. A judge in the District of Columbia declared the search engine a monopoly, maintained in part by tens of billions of dollars Google pays each year to companies like Apple to lock in Google as the default search engine presented to consumers when they buy iPhones and other gadgets. And in December, a judge declared Google's Android App Store a monopoly in a case brought by a private gaming company. In the search engine case, the judge has not yet imposed any remedies. The government hasn't offered its proposed sanctions, though there could be close scrutiny over whether Google should be allowed to continue to make exclusivity deals that ensure its search engine is consumers' default option. Peter Cohen, a professor of management practice at, is that Babson? I don't know the fuck to say that, at Babson College, said the Virginia case could potentially be more harmful to Google because the obvious remedy would be requiring it to sell off parts of its ad tech business that generate billions of dollars in annual revenue. Divestitures are definitely a possible remedy for this second case, Cohen said. It could be potentially more significant than initially meets the eye. In the Virginia trial, the government's witnesses are expected to include executives from newspaper publishers, including the New York Times Company and online news sites that the government contends have faced particular harm from Google's practices. Google extracted extraordinary fees at the expense of the website publishers, who make the open internet vibrant and valuable. Government lawyers wrote in court papers. As publishers generate less money from selling their advertising inventory, publishers are I'm about to say publishers are published. Publishers are pushed to put more ads on their websites, to put more content behind costly paywalls, or to cease business altogether. The government's first witness was Tim Wolf, an executive with Gannett Co., a newspaper chain that publishes USA Today as its flagship. Wolf said Gannett feels like it has no choice but to continue to use Google's ad tech products, even though the company keeps 20 cents on the dollar from every ad purchase, not even accounting for what it takes from the advertisers. He said Gannett simply can't give up access to the huge stable of advertisers that Google brings to the ad exchange. On cross-examination, Wolf acknowledged that despite Google's supposed monopoly, Gannett was able to work other competitors to sell its available inventory to advertisers. The government's case also attempts to use the words of Google's own employees against them. In openings, Justice Department lawyers cited an email sent by a Google employee wondering whether Google's control of the technology on all three sides presented a deeper issue to consider. The analogy would be if Goldman or Citibank owned the New York Stock Exchange, wrote the employee Jonathan Bellick. Google disputes that it charges excessive fees compared to its competitors. The company also asserts the integration of its technology on the buy side, sell side, and in the middle assures ads and web pages load quickly and enhance security. And it says customers have options to work with outside ad exchanges. Google says the government's case is improperly focused on display ads and banner ads that load on web pages accessed through a desktop computer and fails to take into account consumers' migration to mobile apps and the boom in ads placed on social media sites over the last 15 years. They act like there's now also the same similar ads loading on the mobile phones, just in a different format. What the fuck does that have to do with? I mean, obviously, the difference in the web and mobile shift is extremely important in advertising, but in terms of this case, I don't think that's fucking relevant in my opinion, because there's still fucking ads on mobile, typically, usually, often. Just saying, it just looks a little different. I'm just saying, what the fuck? Anyway, just my perspective. Okay, and then it says, the government's case focuses on a limited type of advertising viewed on a narrow subset of websites when user attention migrated elsewhere years ago. That bullshit, Google's lawyers wrote in a pre-trial filing. The last year, users spent more time assessing websites on the open web rather than on social media, video, or apps, was 2012. That doesn't, okay, and how many people use Google? Because this is about Google ads, bitch, but then if we're talking about the Google ads on the part where they access websites, are you saying that every single website that you run Google ads on, that, you know what I'm saying, are you saying every single one has like no traffic? Because I don't when I decide I'm not doing any advertising at all, I will still get at least 100 visitors a month, if not more. When I decide I'm doing no ads at all, I typically get at least that, if not more. And so, like, that's over 1,000 views. You know, like these are, and there's so many websites, so there's so many views. You know what I'm saying? Like, it's just really, and then there's so many people who are doing so much more better than me. You know what I mean? Like, it's just for me, knowing how many views my clients get on their websites to see this argument is just like, but how many views do your clients, because, okay, but anyway. So processing. I need to do some updates um, in the name of the playlist that I have on all of this, because I think I'm just going to throw all of the monopoly cases into one playlist because I've already kind of covered it lumped all in once because I found about it all lumped in one. And so the documentation's all kind of lumped together here. So like for example, this video is covering a lot of it. You know, it's all of the cases here. So I need to rename my playlist to reflect that. And I need to make sure I go through and update where in the initial complaint, I think I had said and put in the description of the video something about like how I had thought that it was one monopoly court case that was addressing all of these issues, something like that to that effect. But I need to just go edit that to reflect these are different cases. I didn't process that. I was real confused on that before, but now I know. Okay. So also from September 23rd, 2024, we have an article here from Holland and Knight, Antitrust blog. And I think these are the authors, and if so, it was written by Ryan Coxe, I don't know how to fuck say that. Ryan Coxe, David C. Cully, Rachel Marmor, Caitlin F. Saladrigas. I don't think I said this shit right, so sorry guys. Okay. And that article says federal court searches for answers in antitrust ad tech trial against Google. And the article moves into, let's see, let me zoom in a little more. See if I can bring this up. So, since early September 2024, the U.S. Department of Justice presented its case in chief against Google in a lawsuit accusing the company of anti-competitive and monopolistic practices in the complex digital advertising industry. At issue for Judge Judge Brinkema of the U.S. District Court for the Eastern District of Virginia to decide is whether Google is using its size and power to edge out competitors, making it harder for companies to compete in the digital advertising space. This includes whether Google's past acquisitions of other ad tech businesses expanded its control across the ad tech ecosystem, and whether Google established practices that favored its own services over those offered by others. During the trial so far, important industry participants have testified about the competitive pressures to use Google's products, as well as the challenges of competing against its integrated ad tech platform. Other witnesses testified that the challenges competitors face come not just from Google's dominance in the industry, but also from its unparalleled access to user data and the insights it derives from that data, which allow Google to dominate digital ad auctions. The Department of Justice has also highlighted Google's efforts to combat the growth of header bidding, a technology that allowed website owners to receive bids from advertisers without using Google's services. The Department of Justice used internal Google documents to show Google's efforts to control this process and maintain its dominance. The impact of these actions was significant, with revenue for some competitors dropping dramatically. Whether this evidence is enough to convince the court that Google maintained its monopoly in violation of Section 2 of the Sherman Act remains to be seen, especially as Google presents its case in chief as the week continues. Implications abound regardless of the outcome. Will the court turn Google into alphabet soup? A ruling in the ongoing antitrust trial against Google could have profound implications for Google and the digital advertising industry, as well as potential ripple effects across other related industries. Department of Justice victory. A ruling against Google and in favor of the Department of Justice might necessitate divestitures in Google's ad tech divisions, fostering competition and setting a precedent for future antitrust actions. Publishers and advertisers could benefit through more competitive rates and innovative advertising solutions. The antitrust agencies may be emboldened to explore further enforcement actions against other powerful tech companies. Google victory. The decision in Google's favor would likely solidify its market position, potentially influencing the regulatory landscape and affecting competitors' strategies within the Google-centric digital ecosystem. Antitrust enforcers might adopt a more cautious approach, and competitors might adopt through strategies such as collaboration, consolidation, or focusing on niche markets in response to Google's established market power. Broader implications. Regardless of the outcome, the trial's examination of Google's interactions with big tech companies and the consequences of the court's ruling simultaneously highlight and expose the complexity of the digital ad ecosystem. These aspects underscore the importance of scrutiny by government regulators and antitrust enforcers in ensuring fair competition and innovation in the market. The trial's outcome serves as a critical inflection point in the debate over the balance between market dominance and competitive fairness in the rapidly evolving digital economy. Things to watch for when the court turns off incognito mode. Wait, what did I mean by that? Is that like a, because they've been cute with the headlines here, you know? I thought the alphabet soup headline was real cute. But, did they mean like, are they just like, okay. When they mean like when the court makes them show their evidence, is that what they mean? Okay. It says, although Judge Brinkema appears to have taken seriously her duty to ensure that as little of the trial as possible occurs out of the public eye, public access to certain portions of the trial will continue to be restricted due to the sensitive nature of some of the proceedings. When not under seal, the Google Ad Tech trial presents several key developments and issues to monitor in the upcoming weeks. 1. Adverse inference against Google. The Department of Justice is seeking an adverse inference and sanctions against Google, stemming from allegations that Google instructed its employees to adopt cautious communication practices, including the use of self-deleting chats, which allegedly led Google to hide or destroy relevant communications. Like Judge Mehta from the U.S. District Court for the District of Columbia in the recently concluded related case challenging Google's search and search advertising monopolies, that's what we've been covering so far. Judge Brinkema has expressed concern over these allegations. If the court decides an adverse inference is warranted and presumes that the evidence Google hid would have been harmful to Google's case, this could greatly affect the trial's outcome against Google. 2. Data privacy and user protection implications. The Department of Justice's trial has, when not under seal, made public not just Google's conduct, but how the entire ad tech industry works, including the heavy use of personal data in selecting and tracking targeted ads. This could provide other government regulators, including those charged with consumer protections and privacy, with an opportunity to obtain a collegiate-level understanding of how personal data is used to power online advertisements. Such knowledge could, in turn, enable regulators to bring enforcement actions under one of the 7 new state consumer privacy laws now in effect, all of which contain obligations to offer and honor consumer choices related to use of their data for targeted advertising. Decentralization of the ad tech industry, if such occurs as an outcome of the trial, could result in publishers being able to demand that their ad tech providers be more responsive to the efforts of the publishers to comply with privacy laws and meet consumer expectations. 3. Market definition and monopolization claims. Part of the trial's focus is on defining the digital advertising market, with Google urging the court to find that it competes in a broad market encompassing, cannot speak, both sides of the two-sided platform, including publishers, advertisers, and the exchanges that bring them together. The Department of Justice is arguing that the ad tech marketplace consists of multiple independent markets, with Google holding a monopoly share in each component of the market, extracting an unwarranted portion of advertising dollars that flow through its platforms. The court's determination of market definition will significantly affect the trial's outcome and could set precedents for future antitrust actions against tech giants in markets with similar two-sided features. 4. Unified Pricing Rules, UPR. The implementation of unified pricing rules by Google and its effect on competitors and the market at large are under intense scrutiny in the trial. Unified pricing rules arguably simplified ad pricing and management, but also eliminated some pricing control by competitors, potentially to their disadvantage. The court's findings on these practices could influence future regulations and business practices in the ad tech industry. 5. Interactions with other tech heavyweights. Evidence related to Google's interactions with other major players in tech may reveal the extent of its market influence and effects on competition. The examination of these relationships might provide insights into the broader implications of Google's practices on the digital advertising ecosystem and could influence regulatory actions beyond this trial. Stakeholders should stay informed about these developments, as they could have far-reaching implications for the digital advertising industry, competition, and innovation. Okay. So, next up, I forgot about the Guardian being like ad blocking. Shit. Well, it's letting me view it for now. Fuck it. Okay, so next up, we are going to, my bad, wrong button. Next up, we're going to, that didn't work. Fucking take a look at, this article from The Guardian here. And it is called Google's Second Antitrust Suit Brought by U.S. Begins Over Online Ads. With a little sub-headliner thing, whatever the fuck word here, says Department of Justice accused tech giant of more monopolistic behavior a month after judge found it illegally cornered online search. And this is written by Nick Robbins Early, and it comes from September 9th, 2024. And it says, a second antitrust trial pitting Google against the U.S. Department of Justice began on September 9th with a federal judge in Virginia hearing opening statements over whether the tech giant illegally monopolized the digital advertising industry. The case could have far-reaching implications for Google's primary source of revenue, as well as the tech industry and online publishers. The long-awaited trial is the second major U.S. antitrust suit against Google, after the company lost a landmark case last month that determined that company illegally monopolized the online search industry. Unlike in that trial, the Justice Department is seeking specific remedies in its second case, ones that would force Google to break up parts of its business and divest some of its advertising technology. The Justice Department's second lawsuit, filed in January 2023, cannot speak still, centers around Google's acquisition and application of digital ad tech. Website publishers looking to make money from advertising rely on this technology to act as a kind of middleman. Google services allow sites to sell ads on their pages and for advertisers to buy ad space that reaches potential customers, while Google takes a sizable cut of the ad dollars from both sides. Google's monopolies in each of these separate markets was no accident, but rather the result of a campaign to condition, control, and tax digital advertising transactions over 15 years. The Justice Department said in a pretrial filing, this campaign was exclusionary anti-competitive, and mutually reinforcing. The Justice Department singled out several of Google's acquisitions to argue that the company now dominates every facet of digital advertising. Google bought the ad tech company DoubleClick in 2007 for $3.1 billion, which provided the tech giant with an online marketplace for publishers looking to sell ad space. The Justice Department alleges that the DoubleClick now controls over half the ad market for open web display transactions. Over the next few years, Google acquired two other companies, Invite Media and AdMeld, which gave it access to advertisers looking to buy ad space and the ability to connect them with publishers. These deals resulted in Google controlling both the supply and demand sides of online advertising, as well as the point of exchange where those sides meet, the Justice Department claims. In her opening statement, the Justice Department lawyer, Julia Tarver-Wood, alleged that Google had built a trifecta of monopolies through its acquisitions. Google's lawyer, Karen Dunn, meanwhile, framed the government's argument as having an antiquated understanding of how the internet works. No, it doesn't. And claimed Google was just one company among a range of serious competitors. Although there is nothing illegal about the general model of matching websites and advertisers to target consumers, the Justice Department claims that Google has bought a monopoly through a series of ruthless, anti-competitive maneuvers. These include eliminating rivals through acquisitions or exclusionary practices that amount to wielding an illegal monopoly over the industry, according to the suit. One industry behemoth, Google, has corrupted legitimate competition in the ad tech industry by engaging in a systematic campaign to seize control of the wide swath of high-tech tools used by publishers, advertisers, and brokers to facilitate digital advertising, the Justice Department wrote in its complaint. One Google ad executive who is quoted in the government's complaint compared the company's business model to Goldman Sachs or Citibank owning the New York Stock Exchange. The suit alleges that Google uses its dominance to deliberately overcharge advertisers while keeping at least 30 cents of every dollar that flows to website publishers through its advertising technology. That windfall has resulted in the company earning tens of billions of dollars each year from its advertising technology, making up the bulk of its total revenue. The harm is clear. Website creators earn less, and advertisers pay more than they would in a market where unfettered competitive pressure could discipline prices and lead to more innovative ad tech tools. The complaint states, added that it forces publishers to pass the costs on to the consumer through paywalls and subscriptions. It cites one of Google's own employees who allegedly characterized the company's position as that of an authoritarian intermediary. Federal prosecutors are planning to present internal Google documents and witness testimony to support their argument. Executives from publishers, including Disney, the New York Times, BuzzFeed, Fox, and News Corp, are all listed as potential witnesses to testify against Google. Founders and CEOs of ad tech companies, as well as advertisers, are also set to testify. Prosecutors will also call a long list of current and former Google employees. Google's defense in pre-trial filings has been to argue that refusing to deal with rival companies is not an antitrust violation, and the Justice Department is not correctly defining the digital ad market. The company issued a statement earlier in June calling the lawsuit a meritless attempt to pick winners and losers in a highly competitive industry. Although the trial was originally slated to take place before a jury, Google managed to avoid that outcome by paying the government over $2 million to settle claims that its ad tech overcharged federal agencies. Monetary damages. What am I saying? Monetary damage claims usually result in jury trials, while judges decide non-monetary claims directly in antitrust cases. The case is being heard by Judge Leonie Brinkema, an 80-year-old Bill Clinton appointee who previously oversaw the contentious trial of one of the 9/11 conspirators. Brinkema made headlines in that case when she paraphrased T.S. Eliot after the guilty verdict, telling the defendant that he would die with a whimper. So, I wonder, that sounds pretty fucking cold. You know what I'm saying? Like, and then it says Google lost its previous antitrust trial, which focused on its dominance over the online search industry, after a federal judge ruled in August that it had built an illegal monopoly through multi-billion-dollar exclusionary contracts. The company is in the process of appealing that ruling, and it's unclear what penalties it may face. Damn. And then I got distracted because Guardian's asking for money, whatever. Okay, so now there's a complaint from 2023. I am not reading this right now. We're not getting into this. Oh god damn, this complaint is even longer. So the initial complaint for the first lawsuit that we covered for the 2020 complaint for the search ads and the search case, that was like 68 pages, but actually reading it was like 58, or it was like it was like 64 pages, but actually reading like 58, I think. This one, the whole document is 153 pages, and actually reading it is like 144 or something like that. Like, goddamn. Or it'll be like 142-ish, 140-ish. Like, wow. I think. Okay, so I think we will be getting into this, but what we're going to do is get into so what I think I'm going to do is finish up my coverage here of the case on I'm going to finish up my coverage, or as much as I can, particularly as it relates to the evidence. I know certain things relating to the appeal have not come out yet, so I might cover that down the road when it comes out. But immediately, I'm going to finish up my short-term planned coverage on the search ads monopoly case as it relates to Google from Judge Mehta, Mehta. And then after I finish that, I'm going to get into the other monopoly case covered by Judge Brinkema, if I'm saying that right. So we're going to cover that one on the ad tech monopoly after I get through some more of that search ad evidence and material and some of that other shit I wanted to cover. Then we're going to get into and focus more on that case. We'll still cover any updates that come up out of the other, but we'll transition to this other case. And fucking also I think I will be just like, if I see any other news, I'm not going to worry about like, separating the news article coverage of it, because it's kind of, the news reporters have been kind of connecting it all and covering it all commingled, connected together anyway. I said commingled, but whatever. Yeah, so I'm not going to worry so much about separating the cases from the news reporting, because it's kind of like, that's how I found out about it all. It's been kind of all covered as one clusterfuck. But in terms of the court documents, so far, we've only gone through the court documents from the case that was filed 2020 with Judge Mehta, I think is how I've been saying it. That dude about the search and the search ads, I'm gonna wrap up that coverage, and then I will start covering and get into this other case here. And that is with the monopoly as it relates to the ad tech under Judge Brinkema. All right, now moving on, we are going to cover. Um, I want to take a look here at this video, US versus Google, inside the biggest tech antitrust trial in decades. And this is coverage from Amanpour and Company. And so I just wanted to see here what other additional commentary people, someone who is from PBS, so this is also from PBS news coverage here, what is being more officially reported on about this case. I figured we could do a reaction to that to wrap up today's stream, and then I'm going to go do my corrections on everything, and we'll wrap up and everything like that going forward. Um, so yeah, basically a lot more is coming from all of this is what you need to know. Okie dokie. So here we go. I'm going to, I think we're just going to do it at regular speed. Fuck it. Make sure I got my captions on. Hopefully it doesn't give me no bullshit. And here we go.
Now to the world of big tech. In a landmark case in the United States, a federal judge has found Google guilty of U.S. antitrust violations. It's a staggering defeat for the tech company that could upend decades of dominance and potentially reshape how millions of Americans get their information online. The Assistant Attorney General Jonathan Kanter joins Walter Isaacson to discuss the verdict and what comes next.
Thank you, Christian and Jonathan Kanter. Welcome back to the show.
It's wonderful to be here.
You had a really big victory in your Department of Justice antitrust case against Google. It's the biggest antitrust case in at least 20 years. And the judge ruled this past week that Google is a monopolist, and it has acted as one to maintain its monopoly. But
I am wondering if the ruling, as Google being a monopolist and has the fact that they've acted to maintain it, if that ruling can be used in the next court. Is that allowed? Like, is that going to hurt Google? Or do they have to disregard that legally? I don't know. You know what I'm saying?
let me read you something else that the judge said. He said, it has hired thousands of highly skilled engineers, innovated consistently, and made shrewd business decisions. The result is the industry's highest quality search engine. So what's the problem here? It got a monopoly by being the best. What are you going after them for?
We want companies not just to obtain power by being the best, but we want them to try to compete and maintain their position.
My thing though is if they got or maintained their power by being the best, then why would they need to pay people off to maintain their status? You know what I'm saying? That's just my question.
By trying to be the best, not engaging in contracts or monopolistic behavior that prevents them and insulates them from competitive pressure. Ultimately, we believe that all companies, whether they're big or small, do better and deliver more for the public when they have other companies, competitors nipping at the heels. It's the fundamental basis for our market system. In order to have a market, you need competitors. And so we want competition driving companies like Google and all other companies to do better and to deliver more.
So what did it do that was anti-competitive?
The court decision explains a whole range of conduct, but
yeah, dude, what didn't they do? So one of the things they did was they had these exclusive contracts with the people that were involved with them. So for example, with Apple, they have a contract where Apple's only allowed to use Google for Safari for their default search engine, for example. And so that's one. So they have those types of contracts. And then they have a contract with Android where Android has to put Google search bar on the home screen, for example. And then in these contracts, these companies are making a bunch of money. So they get revenue shares based essentially to do that. So they do get paid for it. But because of that payment, they financially, like they've done the math, and those companies have no incentive now to offer another product because they would lose too much money to do it. And then where they were also making it so like they were saying, like if in these agreements too that were exclusive, like if these other programs and companies didn't do what Google wanted, then Google would say, well, now you no longer have access to us. And another thing they did was bundle everything. Um, so you couldn't just, they wouldn't allow you to do one app unless you got all of them, and you had to put them on the devices so they were undeletable. That was something that happened with Android, and things like that. And with Android, they also made them do a deal where every app on the phone has to be put out through the Google Play Store, shit like that. You know what I'm saying? Like, so it's like this whole clusterfuck. It takes a lot to process.
Generally, it falls into the category of paying partners to make Google the exclusive default or the exclusionary default, meaning that rather than saying use us because we're the best, we're going to go to our partners and we're going to pay, in some instances, tens of billions of dollars a year to keep them from working with rivals.
It's sort of like what Standard Oil did 100 years ago in that great antitrust case, was try to prevent competitors, even though it gave a very good and less expensive product.
Yeah, history has a tendency to rhyme. And so if you look at the issues that came up in our case here against Google, they resemble many of the same issues that were present in Standard Oil and many of the same issues that were present in US v. Microsoft. And so ultimately, the monopoly playbook is one that repeats itself over and over again. And it's important for us to enforce the antitrust laws when we see that playbook come to fruition.
You talk about US v. Microsoft about 20 years ago. In preparing for this, I talked to Joel Klein, who had your position back then and brought that case. And he said one of the major things was that Microsoft at the time, because that was they were going after, was leveraging its monopoly in one field, meaning operating desktop system, to get dominance in other fields. Is that relevant to this case?
Well,
My opinion is, yeah, I think so, because they will leverage their dominance in search, for example, to then dominate in advertising, for example. I think it's all connected. That's just
Microsoft decision was cited throughout the court's opinion in US v. Google. And that was the last major, frankly, the last monopolization case that the United States Department of Justice brought before filing US v. Google. So these cases do not come along very often. They're very resource intensive and they're historic. And so the legal principles that were established in Microsoft, of course, were highly relevant to this case. Many of the same characteristics that were present in US v. Microsoft were also present in US v. Google. In particular, the importance of network effects or feedback effects. The idea in US v. Microsoft was, do the antitrust laws apply to the technology industry, the PC computer industry? And the answer to that question was unequivocally yes. Same kinds of questions came up in US v. Google. Do the antitrust laws, and can they apply in a world of the internet, a world where products and services are given to consumers for free in exchange for advertising? The answer, once again, was unequivocally yes. The court found that the antitrust laws not only do apply, but that Google engaged in conduct to break the antitrust laws.
Ever since the Sherman Antitrust Act and the Clayton Acts more than a century ago, there have been two prongs to antitrust theory. One is harm to consumers. Do you raise prices? Do the consumers get harmed because they have to pay more because it's a monopoly? But the second is something like harm to competition. Even if
and now I'm just thinking about how, like, in the how to start up a startup playlist, I've been shitting on how two of those lectures that we've looked at so far have encouraged the concept of a monopoly. And so, but in those lectures, none of them ever addressed the risk of harm to consumers. And I think, if that was something that was discussed more about, like, maybe we wouldn't end up here in this case. Maybe I'm wrong, but, something to think about.
a product is free, like Google search is free, and for that matter, Microsoft bundled the browser for free. It doesn't directly harm consumers, but it harms competition. Why should that be part of antitrust law?
That's the basis of antitrust law. Antitrust law exists to protect the competitive process because we believe that competition, rivalry in our economy encourages people to do better, encourages people to deliver more, and encourages lower prices, more innovation, greater output. But it's also important to the diversity of views and ideas. When we get our information, especially on the internet, we want to have a range of sources of information so that we can be a well-informed electorate and citizenry. And so this is a really important part of why we have antitrust laws in the first place. And you're absolutely right. US v. Microsoft did not.
And that's some like super formal wording to basically be like, yeah, you need to pay attention to what the fuck these big businesses are doing so they don't fuck your ass over. But yeah, what he said was like way more professional. You know what I'm saying? Like, yeah, I couldn't do that. Could not do that. I am not professional enough. Also, I just want to take this reminder real quick to remind you, if you're near Pasadena, Texas, near Houston, Texas, you're thinking about getting a tattoo, check out Ink by Cast Tattoo, also known as the V-Hole Studio. Now, back to our viewing here of US versus Google inside the biggest tech antitrust trial in decades. Published by Amanpour and Company, and it is a republishing of a PBS broadcast.
Focused on higher prices. It focused on harm to the competitive process because that impeded innovation. It impeded market forces from delivering benefits and results to the broader economy. It's exactly what we had here in the US v. Google. The one exception, though, is we do have a very important part of the US v. Google case that focuses on price. It's advertising. And so one of the key markets at issue in US v. Google was text-based advertising, which you get people.
Honestly, the way Google is able to control the pricing of digital advertising, particularly as it relates, to pay-per-click advertising and things like that, and the search display network, and as it relates to the platform where they're the main way that all websites who have advertisements on their site, Google is like basically the main platform for which that happens for the most part for the general person. There are other, like, for example, if you want to get into other types of programmatic advertising, some other demand side platforms, they will have like a minimum of like $10,000, for example, for you to be able to even run an ad on it. And so most ad platforms aren't available to the general public because most people can't afford that shit. So we got to go with cheaper shit, which is Google, right? And so that's where they have this like complete dominance on in the market. And so where they also have been trying to argue like, well, you can go buy from other people, like, and spend how much money, sir? Who can do that? You know what I mean? Like, I don't know. So
buy on search. And these are not just high-priced advertisers. Virtually every company, whether it's a virtual storefront or the corner store in your local area, buy search ads, and they buy them in large volumes. And when the price of ads go up, the prices of the products being advertised go up. So this is an issue that not just affects the internet highway, it affects our main streets as well.
You talk about how this paves the way for innovation, this type of decision, by making sure that there's a lot of competition. When I talk to my Tulane students and they all want to start businesses, I often say, okay, but what would happen if Google decided to go into that business and crush you? And that is why we sometimes don't have a whole lot of startups. Can you explain specifically why this would pave the way for innovation?
Yeah, there's a term of art called kill zones. And so if you talk to venture capitalists, they'll tell you that if you're in a kill zone, meaning that the business that you're going to go into can be elbowed out by a large monopolist, you're better off just not investing in that business in the first place. That is not helpful to our economy and our economic growth. And so what we want is we want the best ideas, the best innovation.
I don't know why, but this just reminds me of the South Park episode where Walmart comes into town and destroys all of the businesses. Or is it Walmart or Whole Foods? Or don't they do an episode on both? I'm overthinking. I'm blurring it all together, but I feel like there's a South. Unfortunately for me, not Google, YouTube got disconnected and then it got reconnected. And so I don't know at what point that that happened here. And so I'm just gonna go back, like we're at like 7:51. I'm just gonna go back to 7:15. Fuck it. Sorry if I'm replaying, because for me it got disconnected and reconnected, so we might be replaying part of this here. But whatever. We're gonna bring this back to 7:15. Keep playing and moving forward, and hopefully that didn't fuck it up too much. I don't know what happened there, because like when it disconnects or reconnects, sometimes it'll do that and it'll still be one fluid stream as if it was never disconnected. And I'll be like, okay, cool. But then other times it'll do that, and then there's like this, it'll just cut to the next part and it will miss something, you know? And so I never know what I'm gonna get. Fuck it. Life's like a box of chocolate. Okay, I said life's like a box of chocolate. Fucking stupid ass captioner didn't get that right. Alright. Internalized ableism. Was it internalized if I'm projecting it onto an object? Okay. Externalized ableism. I need to work on that. Fucking anyway, but okay, so back to this. My bad. If you see part of this again, or if it misses part of it, it's because OBS crashed on me. That's unfortunate. Life is hard. You're
business that you're going to go into can be elbowed out by a large monopolist, you're better off just not investing in that business in the first place. That is not helpful to our economy and our economic growth. And so what we want is we want the best ideas, the best innovations, the best products and services to compete on the merits.
Kent Walker, who's Google's president of global affairs, said of this decision, he said, the decision recognizes that Google offers the best search engine, but concludes that we shouldn't be allowed to make it easily available. Is it possible that this case will end up with us getting worse search on the internet?
I think depending on what happens with this case, if they don't get dismantled, I don't. I mean, depending on what happens there. If nothing happens with the concept of they could be dismantled and it just impacts what they can do with the agreements they've been doing, then I think maybe hopefully we'll see some improvements with search of other if in but I don't think much would change. I think if they actually dismantled it, and then we are going to see differences in our search engine situation. But I believe things will get worse before they get better. I believe eventually things will shift out, work out. But I think this could. So right now we're already experiencing like an issue where um, nothing on the internet, on a certain level, things on the internet can last forever because if enough people document or preserve the content, then there are ways then that things have been preserved over time. So it feels like that's possible. But on another level, um, right now you'll be like if you go how many times you go click a link and you know there used to be shit on that website and now there's nothing there, you know what I'm saying? For example, like, or how many times, like, like a link dies but there used to be content there and now it's not, like, to another extent things come down on the internet all the time. And like I was seeing on TikTok, I don't know if this is true or not, but on TikTok they were saying how the archive website is starting to have things removed from it. And like I've been, just seeing people talk about how it can be difficult online to access content you used to be able to find. And so I think if there are shifts in um, terms of Google isn't able to produce enough money to do what it's been doing, and it can't maintain crawling for the web pages it's doing now and indexing now and all of that type of stuff, there could be potential for it to be way harder to access things online and find things online. And it would take time for that to work out, I think. I don't know. Who knows? I can't predict the future, but I just see some shit like that going down. But okay, let's keep going with our programming here.
I believe the words of the court, which is the decision stands for the principle that Google is a monopolist and behaves like one in order to maintain its monopoly. Competition, whether it's competition among small companies or competition against a very large company, yields better outcomes for everyone. And that's the principle of the antitrust law. That's the principle embedded in the court's decision. And we're thrilled that the court agreed with our arguments, and we look forward to taking this to the next phase.
And last week's verdict, which Google says it's going to appeal, the judge hasn't yet ruled and you haven't yet presented on what the remedy should be. What is the realm of what those remedies could be?
It's important that we respect the process. And so with respect to this particular case, I can't comment on what we might request or suggest to the court. There's a proceeding that will a process that will take place. It'll start in September, and we look forward to engaging with the court. Generally speaking, outside of this case, there's a rich body of law that explains what we should think about in the context of remedies. And US v. Microsoft is a good example where, in that case, the court, both at the district court level and at an appeals level, said that remedies should be forward-looking in nature in the context of an antitrust case involving technology. And so making sure that the remedies are meaningful, making sure that the remedies reflect the violation, which in this case is monopolization and deals with.
I wonder if the AI aspect of ad technology or the machine learning aspect of it with the algorithm and the ad serving is where they're trying to, because before we were talking about how Google was trying to basically argue that the government doesn't understand how the internet works now. So I wonder if that's what they're trying to argue with. Well, you just don't understand it. But then here's another thing: if they don't understand it and they're not willing to share the discovery, could it be because they're withholding information? Is that what that's an admission of? You know what I'm saying? It's just me processing, just wanting to know. I don't know shit. I'm just thinking, okay.
The monopoly and making sure that remedies reflect the market as it exists today and as it will exist in the foreseeable future are important principles to keep in mind in any case.
You talked about how this case involved not just harm to consumers, but harm to the whole competitive process, and that both those things are important in antitrust law. But let's go back in history. About 40 or 50 years ago, there was a major shift. Chicago School, Justice Scalia, many others saying, let's just focus on price. If it doesn't harm consumers, no harm, no foul. Is this been a shift recently with you and Lena Khan and others to get it back into balance with both of those things considered?
The shift has been to bring it back into balance with the law. The fact is, the law has always been quite clear, and it was recently reaffirmed by the United States Supreme Court that antitrust doesn't just apply to people who buy things. It can apply to people who offer their labor in the context of college athletes. And in a case involving the NCAA, the Supreme Court explained that antitrust violations geared at people who work are no different than antitrust violations geared at people who buy. The antitrust laws have maintained these principles. In fact, we blocked a transaction involving book publishers on the basis that authors would be deprived of competition for advances for professional original works of authorship. And so these are really important principles. Antitrust ultimately focuses on competition. There have been a number of red herrings that put in place about price. Let me be very clear about this. Price matters. Antitrust cares a lot about the welfare of consumers. It cares a lot about making sure that competition can deliver the best, lowest prices to consumers. And that's something we bring a lot of our cases to focus on, and we care about deeply.
You know, I was thinking too, though, if what happens, where they're talking about the price and how Google has maintained a monopoly on the price to keep it raised. If this court case, if they're able to solve that issue as allegedly intended with this court case or whatever, if that were to work out, then perhaps that could lead to a situation in which it's easier actually for businesses to run ads and make money and succeed and do well. That would actually be pretty nice. I don't know if I don't know. Is that too much of a dream? Is that should I be more realistic? But it's a nice thought, right?
it's just not the only value that is embodied in the antitrust laws.
We live in a really polarized, partisan age, and almost any issue, immediately there's a split. But what surprises me, or in some ways pleases me on this one, is this is a case that was originally brought by Bill Barr, President Trump's Attorney General. People like J.D. Vance have praised you and Lena Khan for doing this. Why has this not become a partisan issue, and to what extent is there some ideological?
In my opinion, people, I feel like this divide or whatever, it's like with the whole bipartisan thing, it's two wings of the same bird. There have been many times that Democrats could have codified Roe versus Wade, for example. And I feel that there are things that Democrats could have done to, you know, to do better in regards to protecting our human rights in relation to that law. I don't know enough about the law to use the correct words, but I'm just saying I believe they could have done more shit. And so I'm saying this for an example, right? But why didn't they? If they harp on the fact that what makes them different from Republicans is that they allegedly support women's rights and human rights and things like that, blah, 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 why wouldn't they do that? For example, just an example. And there's so many more examples, that's just like the first one off the top of my head. So like I'm thinking, it's about the flow of money. And when you look into it, who is funding everything? Where does the flow of income go? Really, the whole point of it doesn't matter. Is like, as long as we live in this it's just all based on colonialism, capitalization. Either way, whether you're voting for a Republican or a Democrat, you're voting to maintain and uphold colonialism and imperialism. And both of them have that same goal. You know what I'm saying? Democrats and Republicans are both colonizers. So you don't get much of a, like, so when people are all like, oh, it's a bipartisan issue, I guess it's because, they even if they have the same goal, they move that goal forward by pushing different agendas and different campaign narratives in order to get different audiences aligned with it. You know what I'm saying? But at the end of the day, you're all going in the same direction, in my opinion. That's just me. But
Divide here on antitrust enforcement.
Because I think this is an issue that resonates with the broader public. People want to make sure that they have the benefits of a competitive economy, because a competitive economy results in greater opportunity, whether it's a farmer who cares about return on investment for their cattle, or somebody who cares about getting affordable access to healthcare or lower prices at the checkout line of your grocery store, and everything in between. People want opportunity, they want economic freedom, and they want choice. And whether it's a conservative or someone on the other side of the political continuum, they don't want any one company or any one ideology telling them what to think, see, or hear. And I think these are important principles, and it's one of the reasons why they've generated so much support across the political continuum. But ultimately, the values of the antitrust laws are about rule of law. The antitrust laws were written by Congress, enacted in 1890, updated many times since then with the Clayton Act and a number of others. And our job is to enforce the law as we find it, based on the facts, based on the law as we find it. And so if we stay focused on making sure that we are engaging in law enforcement and doing it for the right reasons when the facts support it, I think we're going to find widespread support, and that's exactly what we've encountered.
In a recent interview with the Financial Times, you talked about AI, artificial intelligence, and said we have to look at what are the monopoly choke points for AI. What does that mean?
That means that in any industry, especially an industry involving technology and feedback effects that has a transformative impact on our society, it's important to make sure that we're preserving competitive process and we're doing so in real time. And so when people talk about AI, it's no different than when they talk about the internet or they talk about computers. They're using very general terms for an industry that has lots of different components. And so when you think about AI, it's not a single technology. It's a constellation of technologies, from chips and hardware to software layers to applications to agentics to all sorts of use cases and scenarios. It relies on data. You have general data, but you also might have industry-specific data. You might have healthcare-based AI or certain types of enterprise-based AI. It's important to make sure that we understand those distinctions, the importance of all those different variations, and ensure that each one of them, each market within the broader umbrella of AI, has the opportunity to be competitive so that innovators can innovate.
Well, wait, let me pick on data, because that's the one you use. I mean, should Google have to share its data? Should Apple have to share the data on the phones?
Well, these are important questions, right? And so I think there are a lot of broader questions, especially around privacy and ownership, whether data is.
My opinion, to a certain point, like companies do need to be able to protect their data, because that's what allows you to be able to have a unique selling proposition and be different than others, is to not disclose to other people how you do what you do, so that way you can do it in a different way than them. To your regard, like, you should have the option for that. For me, I'll tell everybody what the fuck I do. You just have to charge me to do it for you. Wait, I charge you to do it for me. What? I can't say it. I just have to charge you for me to do it for you. You know what I mean? You have to pay me for me to do it for you. I charge, is what I was thinking. Misspoke there. But with fucking another level though, like, I don't think just general public, like, so if general public company data should be private also to protect the data of others too and all that. But then on another level, I think that all businesses and people should be making our data public, because it's greed to want to keep something for yourself without sharing it with others, and you should be passing it down so that way things can be continued. Because when we gatekeep things and we keep knowledge, that is typically leading to avenues where that starts to die off. Typically, if you are gatekeeping something, it should be to preserve it. But in this situation, it's not in a situation where it needs to necessarily be preserved due to not having access to it, because we're all using it. So therefore, we need access to understanding what we're using. You know what I'm saying? Like, I don't know. To a certain level, when you get to this big where everybody's relying on you, I think there's a certain duty also to be very transparent about how you're influencing people and what people are engaging with, and giving people the opportunity to be able to practice this same type of business for themselves. But by buying out any avenue any competitor would have of being able to put their offer in the market, then it's just like, well, now they're fucked. And then when you look at the big ad part, the ad tech trial, when you look at the ad technology, that makes it even worse, in my opinion. But that's just me. I'm just processing still. Okay, let's watch the end of this video.
It's a public good. But the reality in these technology-driven markets, especially markets that have machine learning, is that data is the oil. It's the oil that makes these businesses run. They learn by doing on large amounts of data, and not just large in terms of what we might consider, a big book or a library. We're talking about the likes of volumes of data, the likes of which we can't even imagine, running through servers or placed across the world. And so if data is critically important, then it is a fact that we have to understand to determine how the competitive market functions. And so if you need access to massive amounts of data to compete, that is a market reality. I'm not saying that it necessitates that companies have to share, should or should not share data. I'm simply saying it's a market reality that we have to recognize when understanding how competition works.
You talk about how sometimes the most meaningful intervention is one that happens in real time. You just said we have to do this right away. You know, if you would why not just let the market play out for a while? In fact, Google probably could have lost its dominance in search by the advent of AI. Isn't it better to let things settle out before we just barrel in?
I think one of the lessons that we've learned is that in technology markets that have massive network effects, markets can tip. And when they tip, it becomes exponentially more challenging for rivals to compete because of the scale, because of the data that's necessary. And so what we want to do is we want to make sure that if it's necessary and the facts and the law support it, that a little bit of intervention early on will hopefully eliminate the need for massive intervention or regulation later on. We want the competitive market ultimately to be the regulator. We want competition. We want companies fighting it out to deliver better and more, to encourage and deliver more benefits to entire society. If we have monopolies, then we lose those benefits of competition. And then often we are faced with either regulation or, in this case, against Google and others, a backward-looking remedy that tries to address 15 years of anti-competitive behavior. It's much harder to do than it is to eliminate a few small impediments in real time. So I think what we've learned is that when it's mandated and it's appropriate under the facts and the law, that a little bit of intervention early on can hopefully save us from unnecessarily invasive regulation or intervention later on.
Jonathan Cantor, thank you so much for joining us again.
All right, and that is the end of that video there. And so yeah, I feel like that was a really good reflection for me to think about what are the impacts going to be from this ad tech case that's taking place now, particularly as it comes in relation to the search ad case that we have also been covering. So yeah, fucking a lot has been happening here, a lot has been marinating here. So this live stream, the most important thing for me that I was processing myself was just the fact that, so first I was confused about the fact that I didn't know if this case related to just I didn't know that if there was one case for all of the monopolization accusations, or what the case I was reading was specifically focused on. That part I didn't understand from the legalese. But after processing all this documentation, and then after the initial complaint, I had thought from the wording in the initial complaint that perhaps that this document was related to all of the advertising. So the search ads and the advertising. I thought it meant both. But now, after this live stream, I know there are two different cases here. What we've been covering is as it relates to, not in terms of the news reporting we've covered has all of the cases commingled, but in terms of the legal documents only. So far, we've only gone through the case as it relates to the search and search ads from Judge Mehta, Mehta. That initial complaint was filed in 2020. Next, after we wrap up because there's more I want to cover on that. After I wrap up my deep dive into my main dive into that legal documentation, next I want to dive into this other case here that is going to be decided by Judge Brinkema as it relates to the Google ad monopoly relating specifically to the ad technology. So yeah, those are two different monopoly cases. I first didn't know, I was confused. Then I thought, in my last live stream, I had thought that it was all one case. Now I know different cases here. So yeah. And so going forward, what we covered today, my bad. I'm going to recap what we covered today real quick. We literally, first of all, we went through the differences between the initial complaint and the amended complaint in the search ads case, in the search ads case, from Judge Mehta. And we went over that, and which the only difference in the initial and amended complaint was just that they added Wisconsin. And I read the entire initial complaint in my other live stream. You can check out on that. And after that, we went into the motion to dismiss the appeal, if I remember correctly. We went into all of that. And then I wanted to, that was important though. At first, I had thought that that was related to the appeal. When I initially decided to cover it, I thought that was related to the appeal in terms of they had said that they were going to appeal the case. But after reading it, and obviously with the timeline, this was filed February 2024, so that's before anything's been decided to appeal related to the case, right? And so this is for this dude named Brad Greenspan from MySpace had tried to get his MySpace shit involved in this case as well, I think, and the United States was basically like, nah, you ain't got shit to do with this, stay the fuck away. And that's really poor, rough summary. I could be wrong. But basically, you know what I'm saying, is my interpretation of what happened. And so we looked into that. And then after that, we basically, we went into some things that I noticed regarding the discovery. Um, I had noticed the sanctions. And so we looked at the fact that I think that Google was sanctioned because they had been trying to hide evidence and they had to get sanctioned by the court to get that evidence produced. I believe that is what happened if I interpreted that correctly. So we looked at that, and then we just looked over the statement of genuine issues and the counter statement of material facts. And after that, we have wrapped up by going through a bunch of different news coverage and sources on the situation, which I'm really glad we did because that's what helped me process this all even further and better, particularly as it relates to realizing these are different fucking cases and I didn't fucking process that shit. But it's just like information overload. Like I've been saying, I can struggle when it comes to fully processing all of that. So yeah. Also, I forgot to mention, we had also covered the memorandum regarding oh no, I did mention this with the sanction. Yeah, duh. We covered the memorandum for the sanction regarding how Google had to be compelled to disclose the evidence that they were trying to hide. We went over that. So there was a presentation regarding United States et al. Versus Google LLC. Um, and it's like a 186 slide presentation. I can't remember if we covered it or not. It's the plaintiff presentation that is linked in the Department of Justice site coverage on the case with the search and search ads case from Judge Mehta, Mehta. That dude, that case. So I don't remember if we covered all of that or not. So I'm gonna see if we did. If we did not, I will cover it. If we did, I will let you guys know we did that shit already. Fucking and then after I so next, as it relates to this, um, I'm going to do maybe one or two, maybe more live streams where I try and get through as much of the trial evidence as I can mentally handle. You know what I'm saying? Because all of the reason I think it's extremely important to try and look at and process as much of this as possible because this is the most access we are ever going to get, I believe, to the inner workings of Google and understanding how um, the means of our businesses as well as our access to information is controlled essentially, you know what I'm saying? And so yeah, so I'm going to look into as much evidence as I can on this search and search ad case under Judge Mehta. We'll finish that up. I'm going to try to finish that up as much as possible if I can within the next week. And then after that, I want to transition going all the way into the, and that's just in terms of the legal documentation. And then with the legal documentation, I want to then focus on the other case that was originally filed. Um, oh, I apologize. I apologize. Before I go into that focus, also, I do want to cover the remedy framework and the remedies that do get decided when that happens as it relates to the Judge Mehta case, Mehta, with the ad search and search ads. Then with Judge Brinkema's shit, Brinkema's. I don't know how to say that. I don't even think I spelled that right. Okay, as it relates to that other judge's case, as it relates to the ads and the ad tech case specifically, we're going to get into all of that legal documentation next, and we'll cover it. I'm gonna try to cover it in a more organized way than I did it the first round, because maybe I'll be better with it with practice, but you can expect the same kind of thing, I think, similar, whatever. Yeah, in terms of news reporting, the news coverage is how I found out about it, and all of that has been commingled and a clusterfuck. So I'm finding it very difficult to separate the cases from the news reports. That's both why I was part of why I was confused as to if there was a difference in the cases, as well as how I found out no, there are different cases, So that's all kind of been published commingled together. So that I will keep mixing up. But in terms of the legal documentation focus, we'll wrap up with the Mehta case, and then we're going to get into the Judge Brinkema's case. I don't think I'm saying that right, but you know what the fuck I mean. So yeah, and that's where we are at right now. Thank you so much for joining me today. I appreciate you. Yeah, I think I covered everything. Oh yeah. There's another thing. I do want to cover The Verge. The Verge had put out some articles as it relates to these different cases, so I will be going over that eventually as well. And in here, there was another case that we came across regarding how Epic and Samsung, Epic Records, I believe, and Samsung are suing Google. If I got that correct, if I remember correctly, yeah, I think that happened. And from this documentation, I will fucking look into that as well, and I'll probably eventually cover that as well. So we got a lot here I want to cover, a lot to go through, lots coming up. So yeah, I apologize, this is a bit of a clusterfuck. As y'all know, I'm processing this shit, so hopefully as I process it, I'll be able to better explain it going forward, and hopefully as I practice, I'll be able to more smoothly cover this shit in the future. Whatever, fuck it, but we're here now. So yeah, thank you so much for joining me today. I appreciate you, and I hope you have a good day, and yeah, bye. Thanks for watching. Join the loyalty program at noladeafchild.com/loyalty, and check in during live streams to get points for rewards.